Committee of the whole will come to the order. Next bill for our consideration is House Bill 166. The reading clerk will read the bill.
House Bill 166, sponsored by Representative Harshman. Utilities, presumption against early facility retirements, an act relating to public utilities. Mr. Speaker, your committee number 9, Minerals, Business and Economic Development, to whom was referred House Bill 166. Utilities, presumption against early facility retirements. Respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Bear, Burkhart, Duncan, Air, Gray, Greer, Heiner, Western. Noes, Representative Sherwood. Representative Greer, Chairman.
Chairman Greer.
Thank you, Mr. Chairman. I move that when the committee of the whole rises report to do so with the recommendation that House Bill 166 do pass. Mr. Chairman, a little leeway here. Members, we do have a substitute bill that is a corrected copy. Just want to make sure when we get to the explanation, everybody's got the right thing in their hand. Okay, so Mr. Chairman, if I remember my procedure correctly, I'm going to move standing committee amendment number 1, which is the substitute bill. And members, if I could just ask you to vote on that, and so we can just discuss the substitute bill.
Question being called. All those in favor of standing committee amendment number 1 to House Bill 166, say aye. All those opposed, say no. The amendment has been adopted. We are back on the bill. Chairman Greer.
Thank you, Mr. Chairman. Yeah, this bill's genius with a J. I'm going to turn it over to the good Chairman of Revenue to explain it to us.
Chairman Harshman.
Okay, thank you, Mr. Chairman. Members, House Bill 166 as amended. I appreciate the work and really does 2 things. It's a rebuttable presumption because our Public Service Commission is a quasi judicial function. And then it also prohibits cost shifting. And really, Mr. Chairman, if you look on page 2, it starts with the definitions. I think the Minerals Committee cleaned that up some, and I think they particularly on Romanet 2, they referred to current definitions. And then I think the big part on electrical generation facility, they added natural gas. I just had coal in there and they added natural gas to that. I think was really good. Then flipping over to page 3, the meat of the bill is on page 3, paragraph B, line 4. There shall be a rebuttable presumption against the early retirement of an electric generation facility. Got to come prove to us. So it sets the plain rules on this deal. Then, Mr. Chairman, if you go over to, it has rate recovery limitations on 37.3.118 carries over to page 4. So really the idea on this is you got to prove that that this power plant's worn out. This bill falls right in line with the work we've done the last couple of sessions, House Bill 200 and Senate File 159. So I'd stand for any questions. And if you're going to close these down, you got to prove that they're ready to retire. And if you can't prove that, you can't make us pay for it. And that's the bottom line. So appreciate any questions. Thank you, Mr. Chairman.
Representative Henderson. Anyone else? Representative Stith.
Mr. Chairman, members, for the presenter of the bill, this looks like a good idea. Thank you so very much for pushing this through. Just have a question as to how you expect this to play out and whether the committee had any discussions about considering the costs of externalities of sort of macroeconomic damage done to a community where a power plant, for example, gets shut down, whether the Public Service Commission would be entitled to use that as a factor in determining whether whether a shutdown is cost effective or not. If that makes sense. Thank you.
Chairman Greer.
Yeah, thank you, Mr. Chairman. Great question, by the way. Within this bill, the answer to that question is no. Within this building, the answer to your question is yes. A good senator, a good friend of mine has a bill dealing with these external costs, and we should be seeing that bill. It will have that opportunity to look at those other costs that haven't been factored in. What this bill does is in a very subtle way, is making making the public utilities come in and they have to jump the hurdle. They come in and say, we want to close this facility down because our management plan or our shareholders or whatever it is wants to shut this down because they want to feel good about where their electricity comes from. They have a rebuttable presumption. It can't be absolute, but they've got to come in and prove why they're going to do that. And if they have to bring on non-dispatchable electricity, or non-coal or non-gas, which was an addition by our company, they can't take those extra added capital costs and push them on to consumers of the state of Wyoming, but rather have those costs go to those people who want to feel good about where their electron generated from. That's what this bill does.
Question being called. All those in favor of Chairman Greer's motion that when the committee of the whole rise to report, that do so the recommendation for House Bill 166, the recommendation that do pass, all those in favor say aye. All those opposed say no. That bill has passed committee of the whole. 166 has passed committee of the whole. Next bill for our consideration is House Bill 228. Oops, sorry. Hang on, one sec. Representative,
Thank you, Mr. Chairman. Privilege of the floor.
please proceed.
Thank you. Members, if you'll rise with me in the back here. My boy, actually, stand up if you would. Tim, he joined us. It's been a while, but he was a page of the day a couple times. I think 2014 and 2015, he was just a little bit above waist high. Now he's 6'2" and a junior at the Rock Springs High School. They're having their spring break this year, so he came down for me. And as a side note, he introduced himself to one of our great state troopers on the way down with 112 miles per hour. So thank you and welcome, Tim. Thank you.
Spring break with the legislature. That's certainly one way to do it. The next bill for our consideration is House Bill 228. The reading clerk will read the bill.
House Bill 228, sponsored by Representative Roscoe. Highway Closure Violation Amendment, an act relating to highways. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom was referred House Bill 228, Highway Closure Violation Amendment, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Baker, Brown, Burkhart, McGuire, Obermueller, O'Hearn, Stivar. Noes, Representatives Burt, Henderson. Representative Burkhart, Chairman.
Chairman Burkhart.
Thank you, Mr. Chairman. I do this with great trepidation. I move that when the committee of the whole rise to report, to do so with recommendation that House Bill 228 do pass. There are no amendments, and I will turn over explanation of the bill to the good representative from kind of the center of the state, a little bit left.
Thank you, Mr. Chairman.
Representative Roscoe.
Thank you, Mr. Chairman and committee. Bring you House Bill 228, Highway Closure and Violation Amendment. This bill was suggested to me by state law enforcement, by the department that dots its Ys, and by my local sheriff. And I'll walk you through the bill. It shouldn't take very long. It's pretty 2 pages. The purpose of the bill is simple. It is the elimination of one word from the existing statute 24-1-109, which deals with the failure to observe highway closure signs and markers. Please look on page 1, line 12. The bill seeks to remove the word willfully. The problem the word willfully creates is that it makes it really hard to find or prosecute someone who has violated highway closure. It raises the standard of proof necessary for law enforcement or court authority to issue a citation. Use of the word willfully focuses the necessary proof on what was on the driver's mind during the offense. It is not, it takes the emphasis off of the offense itself that was committed. So I could read that one more time. The use of the word willfully focuses the necessary proof to what was on the driver's mind during the offense, not on the offense that was committed. The word willfully is not present in any other traffic code. And this bill would bring it in line with other traffic statutes. There are those who have learned how to bypass this law by stating they do not know or did not see, and therefore did not know the highway was closed. There's also talk about repeated offenders who know they can bypass these signs and gates without recrimination. Law officers feel that their hands are tied. And so they are reluctant to issue citations, fines, or prosecute those who bypass these road closures. By striking the word willfully, this is not found in any other traffic code. It would allow law enforcement to prosecute these offenses. So thank you, and I will answer a question that I know is going to come up before you ask it. So you are not in violation of any law if the gate is closed behind you, or if you pull off of a side road that's unmarked or out of your driveway onto a closed road. These are not trying to get the small offense. It's for big major winter closures where they're closed for several months. There are cars going over, but they're not allowing tractor trailers. And there's been some serious accidents and problems with that. So this would help law enforcement. I'll stand for any questions.
Madam Minority Floor Leader Connolly.
Thank you, Mr. Chairman. And I know the Good Bringer has a one-word bill here, actually a strikeout, right? We're actually making our statute smaller by striking out a word, but that word is important. And I must admit, one of the funniest Facebook posts I saw with the blizzard was of a Wyoming stop sign that had snow all the way up to the top over the word stop. Right. And so that's not the example that you just gave. And I'm curious if someone could be fined for failing to stop at that drifted over stop sign because of this bill.
Thank you, Mr. Chairman.
Representative Roscoe.
Thank you, Mr. Chairman and Minority Floor Leader. That would, if the sign is not closed, is not visible, then it would not be an offense. And the officers have plenty of discretion when they're giving out these citations. So they just feel hamstrung now by not being able to prosecute these repeat offenders and major people that major accidents that happen and they're not be there. Judges are having trouble prosecuting these offenses. Thank you.
Chairman Greer.
Yeah, sorry, Mr. Chairman. Yeah, so he said the police discretion, that always makes me nervous. So I guess I do have a question on this. So we say we don't have the willfully anywhere else in the traffic code, but the question is, you know, why isn't it knowingly or intentionally? Okay. Because if these are our mountain pass or an area and you're in hunting camp and it snows and you come out of hunting camp, road's closed, signs are on down below, but you come back down, you don't know the road's closed. But technically, by the law, which is what we're passing, but technically by the law, you're on the road. And if you strike that word out or a qualifier, you're guilty. And now you got to rely upon the discretion of law enforcement. Well, I get along with law enforcement well now that I'm 50 years old, but there was a point in time. So I just assume that we were a little more cautious on these things. I understand the intent. And I guess my question to the sponsor is, why didn't we say intentionally or knowingly or some qualifier along with that rather than a strict type of liability or penalty?
Representative Oakley.
Thank you, Mr. Speaker. On and for, the reality is I believe the good bringer of the bill is trying to solve a problem that's happening, a significant danger that he's seen in his district, which he can tell you more about. But what this does is basically puts it more aligned in what our traffic citations usually are, which is more of a per se. So you don't get convicted of speeding because you were willfully or knowingly driving 112 miles an hour. It's because you were doing it. And the reality is, as drivers, we have a duty to inform ourselves. And the problem that the Good Bringer's trying to solve is one where I believe, commercial vehicles ignoring the signs and their duties to know and going over a pass is creating a danger. So what this does is shift it back to where the onus usually is and where it should be, which is you have a duty to be a knowledgeable, informed driver and follow the signs that are there and that are marked. And I don't think that's too high of a standard. I'm not sure why this one has willfully, but I think it's fine to put, again, the onus back on drivers to be informed and knowledgeable about traffic laws, signs, and restrictions. And that's how we do it. The reality is signs on the side of the road is how we inform people generally of what the law is. And we all have a duty to follow those. And it's not a defense to say you didn't see the 70-mile-an-hour sign when you're driving 112. And the reality is this is the same. So on and for.
Representative Roscoe.
Thank you, Mr. Speaker. I certainly appreciate the help from Representative from House District 55. And back to the majority whips, the country lawyer's question. He was not in violation. If the road is closed behind him, it is not a violation. Thank you very much.
Representative Henderson, Representative Roscoe, were you finished? Yeah. Representative Henderson.
Thank you, Mr. Chairman. I voted no in committee because I'm concerned about the potential for reducing the constitutional rights that you're innocent until you're proven guilty. And the rationale that this makes it easier to prosecute is not persuasive. I don't find that persuasive. Now, in a particular area where there's a problem. So for example, if there had been testimony in the committee that there'd been, hundreds of these folks who had committed this violation, whether it was knowingly, willfully, or otherwise, I think the frequency of that act or that going against the posted signs and so forth would warrant something that may be close to this. I'm not sure we're at where we need to be on this, but how would you see, do you have information on the frequency of how many cases there have been where you've indicated that folks have come and said, well, hey, I didn't see it, or I didn't know about the limitation?
Chairman Olson. Representative Roscoe.
Thank you, Mr. Chairman. I think this has been addressed that it would bring it in line with all the other traffic statutes so that are not willfully, it's not that you have, and I got this from the Highway Patrol Academy attorney up there. It's not like a speeding ticket where, you were you willfully speeding or not? You were speeding, right? And it's not whether you weren't looking down at your speedometer or whatever. You were speeding, and that's what they're trying to get this to. It gives them the opportunity to give some of these repeat offenders. And I'll give you an example, which is my neighborhood, Teton Pass, which there are thousands of people that go over daily to Idaho because they can't afford to live in Teton County. And those are our people that work there. There's a winter closure of several months, and they're not allowed, semi trucks are not allowed. It's 10% really steep. Maybe I've said this already, but someone comes up from the south, they drive on up, they go by 4x4 signs that are flashing lights, and they get halfway up and they jackknife and they block the traffic for hours, if not days. So, and there's been a few serious accidents because of this. And so that's what the Highway Patrol and law enforcement is trying to avoid. And they would just like to bring this in. Also, the same guy from the academy said that he had no idea why that willingly was put in there to begin with. So they're just trying to clean it up and make it like all the other traffic offenses.
Representative Olson.
Yeah, thank you, Mr. Chairman. So I do think that the discussion that we've had so far is urging the body to seek caution on the bill, actually. And I do think that if this bill is going to move forward on a second or third reading, it might be wise to add some type of mens rea, whether that's intentional or knowingly. I want to push back a little on some things that have been said because I think it's a little inaccurate how we compare this to our other traffic laws and say you're driving 100 and maybe 112 is a bad example, but you're driving over the speed limit. You're driving over the speed limit. There's no defense. That's not true. It's not a strict liability because we actually have, for example, I'll give you one statute that is a defense. We have a statute in Wyoming that says that you may accelerate your speed at a reasonable amount to pass another vehicle. Doesn't define in statute what that amount is, but you could accelerate to pass another vehicle. That's codified in our statute. So there is a defense. There is a defense to speeding. What you do if you pass this bill and delete willful is you eliminate all defense. So it does become a strict liability. So it's not an accurate comparison to speeding. I think whether it should be willful or knowingly or intentional could be, I don't know that it has to be hours of debate. The key is, at least from my perspective, to have some type of mens rea qualifier on there, because I think that the questions about whether you can see the stop sign are relevant, whether you can see the rails are relevant, whether it's a snowstorm and a whiteout, whether it's an overgrown bush or a vehicle blocking your path, whatever these things may be, these are defenses to rolling through a stop sign, rolling through a light. And they should be defenses in this scenario too. You're trying to absolutely get the actors that you need to capture under the statute in order to enforce public safety. But you don't want to do that to the detriment of getting the innocent actor. That's why we have a mens rea. So I wasn't here when the statute was written, but I don't think it was an accident that the legislature put willful in this statute. I think they considered, heaven knows how long they debated that word. And I hope we don't debate it that long, but I hope you'll consider that there is a policy reason for this. And maybe if you're going to pass this bill forward, which I would urge caution, that on second or third reading, we just settle on some type of mens rea so we keep those innocent actors out. Thank you, Mr. Chairman.
Representative Washut.
Thank you, Mr. Chairman. I speak in favor of the bill. You know, folks, when these commercial vehicles and others go past these road closed signs and cause traffic crashes, injuries, more complicated road closures, all those things have an impact on us. You know, we have to pay for first responders to go out there in hazardous circumstances to work these crashes. It takes us longer to get the highway open again. Whether it's willful or intentional, we can have that debate on second reading, but I'd encourage you to pass this along and we can work out a few of the details. But this is a major issue in some of these communities where folks are driving past these closure signs with impunity and knowing that they can escape any consequences with the law written as it is. So I'm honored for this bill.
Representative Burt.
Thank you, Mr. Chairman. On and against. If someone can explain to me by removing this word today that we will stop all traffic accidents on this particular pass, I might be for it. But I don't think it's going to stop the behavior of people. It's just trying to change the enforcement of the law. The other thing is, if someone can explain to me, if we remove the willingness, where do we put the burden of proof of innocence or guilt? Does it move back to the individual that's actually driving to prove that they're innocent? Or if we keep it there, does it stay in the courts to prove that I'm guilty? So I do have a couple of different concerns on that particular part. Just by moving that, if someone on the law side of things can explain that, I'd appreciate it. Thanks.
Anyone else? Representative Romero Martinez.
Thank you, Mr. Chairman. I support this bill and hope we can move forward with amendments on the next reading. Thank you.
Anyone else before the sponsor? Or Representative Roscoe? Representative Roscoe, do you want to take us home? Or do you want to call the question?
Question.
Question being called. All those in favor of Representative Roscoe's motion, when the committee of the whole rise to report, do so with the recommendation that bill number 228 do pass. All those in favor, say aye. All those opposed, say no. The noes have it. Division being called. All those in favor, please rise. All those against, please rise. More than 28. No, stay standing. $29 against. Pursuant to House Rule 6-6, bill having failed a voice vote and a standing vote, a roll call vote is required. Chief Clerk, please call the roll.
Andrew, Baker, Banks, Bear, Blackburn, Brown, excused, Burkhart, Burt, Clausen, Clifford, Connolly, Crago, Duncan, Eklund, Air, Flitner, Fortner, Gray, Greer, Hallinan, Haroldson, Harshman, Heiner, Henderson, Hunt, Jennings, Kenner, Knapp, Larson Lloyd, Larson Dan, McGuire, Martinez, Nyman, Newsom, Nicholas, Oakley, Obermuller, O'Hearn, Olson, Ottman, Paxton, Provenza, Roscoe, Schwartz, Sherwood, Simpson, Summers, Stith, Stivar, Sweeney, Walters, Washit, Western, Wharf, Williams, Wilson, Winter, Yin, Zwanitzer, Mr. Speaker, Wharf, excused. Closing vote, are there any changes? Clausen, no to aye. Martinez, aye to no. Further changes? Closing vote. The vote is closed. 24 aye, 34 no, 2 excused.
Having failed the roll call vote, House Bill 228 is indefinitely postponed. Next bill for our consideration is House Bill 171. The reading clerk will read the bill.
House Bill 171, sponsored by Representative Harshman, Executive Branch Funding Restoration, an act relating to the operation of state government. Mr. Speaker, your committee number 2 appropriations, to whom is referred House Bill 171, Executive Branch Funding Restoration, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Kenner, Larson Lloyd, Nicholas, Schwartz, Simpson, Walters. Noes, Representative Stith, Representative Nicholas, Chairman.
Chairman Nicholas.
Thank you, Mr. Chairman. I move when the committee in whole rise and report, it does so with a recommendation that House Bill 171 do pass. I'll turn the explanation over to the bringer of the bill, a good representative from the middle of the state.
Chairman Harshman.
Thank you, Mr. Chairman. Members, bringing House Bill 171. This is a parachute bill. Hopefully it'll pass the House, go to the Senate, pass, sit, and never be needed. And really just bring this bill in case for some reason we don't have a budget or we have another snowstorm, we can't get back together. And I think all of us on this floor expressed that concern that we don't want to leave here whenever we leave and grow the LSRA by at least 200 million, which is a good thing. It's a beautiful thing in this state. We got all these accounts. It's beautiful. I'm glad I was here for a lot of that. But I don't want to leave the state and grow our savings accounts and then have the most vulnerable. I mean, the phase 3 cuts, the Department of Health and Family Services. So here's what the bill does. Appropriates 30 million, line 12, to the state auditor. Okay, flip over. Line 1, this appropriation cannot be transferred, expended for other purposes. Anything unexpended will revert back. Paragraph B, the governor may direct state auditor to transfer the funds of this section for the Department of Health, Family Services, or the Department of Corrections can be expended to restore reductions contained in the governor's fiscal biennial supplemental budget for social service programs delivered to Wyoming residents. So if some reason we fail, we're not gonna do unnecessary cuts to the what I call the worst of the worst. And you supported these amendments in our budget bill. And this is just a parachute. Hopefully it'll pass over there, sit in the majority floor leader's office over there, or the president's office, not be needed. Stand for any questions.
Representative Baker.
Thank you, Mr. Chairman. My question is for the sponsor. If this bill were to pass, how would that affect the goldenrod and the appearance of what we're doing here? Thank you.
Chairman Harshman. Oh, Chairman Zwanitzer.
Just a little more. It's targeted at social service programs in 3 agencies. And so if we could discuss, this language would stop any type of B11 process, I would assume, but perhaps I'm just worried that we've kind of artificially tightened it, but there's still flexibility that existing funds could then move other programs, and maybe some more explanation on why these 3. I assume there are some other social service programs outside of health corrections and family services. I really like the intent and the idea. I just feel maybe it's limiting too much. And then sometimes I feel maybe it's not limiting at all when you can, there's some flexibility in the executive branch to move money around. I just need some more explanation on how it's going to work.
Chairman Harshman.
You know, it's hard to hear right here. So did you call on me, Mr. Chairman?
Chairman Harshman.
Okay, you literally can't hear with this plastic here. So that's why I've been kind of standing here. Too many gunshots. Okay, the first question on the goldenrod. Yes, it'll impact the goldenrod right away. Whenever a bill passes committee of the whole, then it's profile. So that's to answer that question. The second question, is it too limiting? I mean, if you look at the worst of the worst and the good member appropriation standing, that's where what we're talking about. We're talking about in these agencies, and 90% plus of those are in the Department of Health. And these are folks who are on waivers that need care, whatever. I mean, you know, folks like that in your communities, and you've heard from them. And there would be no reason that we shouldn't do this. We've already passed in the budget. Mike, and I think the budget will be fine. Don't get me wrong. But I think this legislature needs a parachute. You don't want to go home as a legislator and say, yeah, I grew our savings by $250 million. And I also, Grandpa, you got to now leave your home care. You got to go to a nursing home, and you don't get your waiver anymore, or you some disability that, so I think we got to be really, we've already voted on this issue already. I just want to make sure that our intent moves forward to help our people in the right way. So I think it's structured, I think, the right way, and doesn't prohibit any further B11s of other dollars, those kind of things. Thank you, Mr. Chairman.
Vice Chair Larson.
Mr. Chairman, I'd like to ask the body to really consider positively on this bill. And it's kind of a reason that kept most of my night last night pondering how to navigate the rules that this guy understands far better than I do, how to get bills passed at this late stage in the game. And the reason I say that is the agency in which most of these cuts were made contacted me, and they're currently, as we speak, trying to figure out the regulations and that will govern the next stimulus dollars. And part of that they're concerned about is if we make a reduction, as we've done in the step 3, that we cannot use any of those funds to supplant. And I will confess, we don't have all of the details, and I think that we'll have them before third reading, which would be on Monday. But I would, this may certainly be the vehicle, because you'll recall we didn't capture all of the step 3 stuff in the bill. And let's just say that the bill, our budget bill, passes, and we get all of those that we did in that amendment that we passed. There were still a number of third reading or step 3 reductions to social services that are not covered and could be, if we implement them, then could disqualify our ability to use these next round of funds for. And I think if we could move this bill down the track, and I will, as that information becomes available, I'll give that to you to help you make a better understanding, but I think it's this may be way to go. We may have caught this and be able to be able to use that more. I hope that makes sense. Vote aye.
Representative Gray.
Thank you, Mr. Chairman. I'm a little perplexed by aspects of this, some of the things that have been said here. For one, if the supplemental budget doesn't pass, then you revert to the original budget, which the governor could just reverse the original reduction. And then you're back to the status quo. So why do you need this bill if the premise behind it is to supplant a potential failure of the budget? The other thing that doesn't make sense to me is it's still a May in that. So along the lines of the previous point, all the governor has to do is reverse the original reduction in the budget that he's currently under, assuming the supplemental fails, and you're back to the status quo. The other thing that I'm concerned about with this bill, in the absence, and this is if the budget does pass, assuming the budget passes and this bill, well then, first of all, our version of the budget, I think, restores less than 30 million. So we're bringing back more than we restored last week, and allowing them to do that on top of that, the way I read it right now. So I just, I'm really perplexed by some of these points that have been made. And I don't think I think if the budget fails, they could reverse the reduction anyway at the governor's discretion. And if it does pass, which I think some form of the supplemental will pass, then I think this brings back 30 million on top, potentially at the governor's discretion, which probably wouldn't happen anyway. But I think it's an awkward deal, and I'm going to be voting no. So thank you.
Anybody else before the sponsor? Chairman Zwanitz, sir.
Thanks, Mr. Chairman. And I didn't get it until the Vice Chairman of Appropriations. I don't know if he meant to say it. The social service programs are federal match programs. This is more brilliant. I didn't realize it is brilliant what we're doing, because you're allowing the money to sit there. It doesn't have to be used, and it's time restrained. But if you get more federal money that can be used to double the state money, then we can use it. And that's why it's directed to social service programs, because they all either have 2-to-1 or 3-to-1 matches. And so you're doubling the investment potentially at the maximum. But any restoration, anyway, I just wanted to say it didn't click and it wasn't explained very well. But now that I get it, it is amazingly brilliant, and I'd strongly encourage your support.
Chairman Harshman.
Do I need to answer any questions? Really, you can't spend money you don't have. So if we run out of money, that's the issue, right? And if you look at so that's that part of it. And the May is, absolutely, if we do have money, he won't spend it. And then finally, I don't think there'll be a double appropriation. I just trust my colleagues down the hall. If we pass a budget with whatever number, there won't be a double appropriation. And then the other little part of this is we're going to learn more about federal guidance. You're not going to be able to use it to supplant cuts. I think the good chairman just said that. And so there's a lot of moving parts. Hey, I don't know how it's going to go. I just wanted to throw a parachute out so we all don't crash land. That's it. And hopefully this thing is never needed. Hopefully we just land safely. Thank you, Mr. Chairman.
Question being called. All those in favor of Chairman Harshman's motion that when the committee of the whole rise to report, it do so with the recommendation that House Bill 171 do pass. All those in favor, say aye. All those opposed, say no. The ayes have it. House Bill 171 has passed committee of the whole. The next bill for our consideration is House Bill 198. The reading clerk will read the bill.
House Bill 198, sponsored by Representative Nicholas, University Water System, an act relating to the University of Wyoming. Mr. Speaker, your committee number 2 appropriations, to whom was referred House Bill 198, University Water System, respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Kenner, Larson Lloyd, Nicholas, Simpson, Stith, Walters. Noes, Representative Schwartz. Representative Nicholas, Chairman.
Chairman Nicholas.
Thank you, Mr. Chairman. I move when the committee of whole rise and report, it does so with a recommendation that House Bill 198 do pass. And I move for your favorable consideration, and I will also move the Standing Committee Amendment number 1 and ask for your favorable consideration on that as well. And I'll bring that up as I describe the bill. So, ladies and gentlemen, everyone should have a sheet. Actually, it's 2 pages that I left on your desk this over the lunch hour. And what it doesn't say is House Bill 198 on it. But it looks like this, and it has my signature on the bottom. And so, and it starts out with the problem. Okay, have y'all found that? So if you follow along with this, then what I'm going to say will make a lot more sense than, because I tend to run on and talk too fast and jump the bridge on occasion. So here's what the problem is. The university operates Jacoby Golf Course. It's been in operation since around 1958. Between 1958 and 2007, there was a general kind of a gentleman's agreement or a 2 entities agreement that if the golf course was a public golf course, that the city would, so all the folks in the town could use it, the city would provide free water. So for 50 years, the water was free. In 2007, the folks over in the Windy City said, well, we're going to start charging you for the water now. And so the waters that they were using to water the golf course are part of the potable water system. So it's been chlorinated, it's been processed, and so it's expensive water, basically. And so, but so went along for about another 10 years, and almost every year for the first 10 years, the city continued to raise what it was charging for the water to the university. So what this bill does is it fixes that problem. And some of you may recall that in 2017, the Speaker of the House at the time brought a bill that we appropriated dollars to drill a well over on the property UW owns by Jacoby Golf Course. So that passed. The well, lo and behold, did not pan out. That's why we used to call him Old Dry Hole on occasion when we'd see him. But eventually then, they bought some property, part of that front face that you see outside on east of Laramie, and they drilled 2 more wells. Those 2 wells came in, are quite productive, so they're permitted at producing, and now they want to use that water and these 2 wells are on UW property, and they want to transfer the water from their well site to the golf course so they can use non-potable water from the water wells to water Jacoby Golf Course. And their estimate is this will save between $150,000 and $200,000 a year to do that. So far, they've spent about $600,000 or $700,000 to get to this point. And then they still need to put in the infrastructure, and they're in the process of funding that. So this is a cost saver for the University of Wyoming. The problem, so there's 2 problems. Number one, it costs money to the city of Laramie and for their water supply. And so as a result of that, our good friends at the city of Laramie in August of last year passed an ordinance. And that ordinance says that you cannot use your well water and bring it from outside of the city limits into the city limits. So the Jacoby Golf Course is basically on the boundary of the city. These wells are 500 feet from Jacoby Golf Course. So under this city ordinance, the folks at UW cannot bring their own water adjudicated and proved up on the well site to cross on their property to water the golf course. And so this fixes that problem. And does it cost money or income to the city of Laramie? Yeah, it does. It'll cost them about $150,000 to $200,000 a year at the current rates. But what's important about that is that currently University of Wyoming uses the potable water from the city, and they pay roughly $1.4 to $1.5 million a year for the potable water. So it's still a pretty good deal for the city of Laramie. But this $200,000, it was an investment that the university wanted to do and chose to do on their own land to deliver water to their own golf course. And in order to then address the ordinance issue, I bring you House Bill 198. And 198, if you have the bill in front of you, is quite simple. Starting on page 1, it clarifies the authority of the University of Wyoming over its own water, and it allows it to transfer water from its property outside of the city limits into the city limits and use it for non-potable purposes. And so my first, I would move Standing Committee Amendment number 1, because what that does on page 2, line 2, you can see it says using potable or non-potable. So the amendment struck potable so that they can only use this well water for non-potable water. And that was just basically the folks from UW came in. We asked them in committee, do you really need it potable to be in there? And they say, no, this is for the golf course and perhaps for irrigating some of those large pastures, the baseball field, and all of those places. And so it's only for non-potable water. So I'd ask for your favorable consider on Standing Committee Amendment number 1.
Any discussion on the amendment? Question being. Representative Provenza, question on the amendment.
Oh, amendment, I'm sorry.
We're on the amendment. All right. Question on the amendment. All those in favor of Standing Committee Amendment number 1 to House Bill 198, say aye.
Aye.
All those opposed, say no. The amendment has been adopted. We are back on the bill. Chairman Nicholas.
Thank you. And then going back to the bill, basically it allows them to use the potable water and to transport it across into the city limits. And it also then, if you go down to the bottom, that has to do with the franchising laws of the state of Wyoming, which allows cities to grant permits or franchises to utilities. And this specifically exempts the University of Wyoming from the requirement of obtaining a franchise to the state of Wyoming to bring their well water onto their own property. So I'd be happy to answer any questions.
Representative Stivar.
Thank you, Mr. Chairman. On and against this bill. What are we doing? Making University of Wyoming a municipality? That's the first thing. And the question I have is when is on line 5, connect to building, facility, landscape, lots, permit, and structures owned by the university. Water line. You don't hook potable water up to buildings. So that needs to be explained.
Representative Provenza.
Thank you, Mr. Chairman. On and against this bill, we've heard a lot from our municipalities about the cost cuts here and how they're not going to be receiving as much money during a time in which they are severely diminished. Additionally, the city, which I will admit I haven't been able to read through the entire thing, but they just submitted a resolution during their last city meeting. This is likely to end in litigation because the city, I think, is arguing that it might not be constitutional. So this is just giving more privileges to the university, who already doesn't really pay much money into the city because they are a university. And so the struggle is we're going to allow them to have special privileges for a golf course. So on and against this bill. Thank you.
Chairman Swanser.
Thanks, Mr. Chairman. I just want to make sure there's no unintended consequences, because as I read the bill, it's not, I mean, it's a golf course would be included, but the university owns a whole lot more than a golf course where I think this would be applicable. I mean, they just bought the Pilot Hill thing east of Laramie. They own Sarek up in Goshen County. So I guess I need the sponsor to just assuage my fears that this doesn't cover any university property in any county or in any city, that they have kind of free reign to not listen to the local city or county ordinances when it comes to water, and they could drill their own wells up at Sarek, which is our agricultural research station up in Goshen County, or on this new land they own east of the city of Laramie. They now basically control that water regardless of what the city says. So just make university-owned properties.
Chairman Greer.
Thank you, Mr. Chairman. Well, I would hope this would apply everywhere. And the reason being is, why are we using potable water for irrigation to begin with? And so I live in a community that has 2 irrigation canals run through it. The water's coming in from elsewhere into the city limits. And there are quite a few people that irrigate. When I say irrigate, water their lawns out of that. Some of them with actually legal right. Others just do it. But it makes sense to me if you were to drill a well for irrigation purposes and then be able to bring that into the city limits and use it. So we're not using an already stressed resource, which is potable water, and the infrastructure associated with the potable water. Why wouldn't we encourage that? And quite frankly, my question would be, who cares if it's university property in Torrington or Powell? Why wouldn't it be all property in the city? So I like the bill. I think it maybe ought to be broader in scope.
Maybe he saw it.
Chairwoman Wilson.
Thank you, Mr. Chairman. On and for the bill, and I just want to bring something up. And first, I'll just say, I don't golf. Never been to this place, this golf course, don't even know where it is. So I have no interest in the particular piece of land. But I would say that reading in the Constitution, Article 8, first of all, Section 1, water is state property. Section 2, the Board of Control is in the Constitution. The state engineer is in the Constitution, who has supervision of the waters of the state and their appropriation, distribution, and diversion. So it seems to me that if the state engineer has approved the wells, this is the job of the state.
Chairman Nicholas.
Thank you. I'd be happy to address some of those concerns. And let's talk about the first one that was just raised, because it's a really important issue here. So the municipalities are creatures of the legislature. We created them. They're not in the Constitution. And the authority that are granted to cities and towns is established by us, by the legislature and the laws that we create. And they can only act within the laws that we grant. So the question is, does a municipality have the statutory authority to prohibit someone from using their well water that is just across the city line to irrigate his pasture that happens to be in the city, or to use that water to his well water that he uses for his grass, or anything like that? The answer is, constitutionally, the city does not have that authority. So there is some real constitutional issues about the ordinance that was passed. There is no question that the UW has the authority to use the water just like you do, or a rancher does, or someone who drills a water well at their house so that they don't have to be on city water to irrigate, has the right to do it. And there's real limitations on what the city can do. Interestingly, if you read the ordinance that was passed, it does a lot of interesting things. It says that every water well in Laramie whether it's been there or not, regardless of how long it's been there, has to be registered within a year or they can shut it down. And it says that if you water more than 25 gallons a minute, then you have to, in order to continue to use your well, you have to provide a GPS location, you have to meter it, and you have to provide that meter reading to the city every year. And I would suggest to you that that is unconstitutional. You can't do it. The water and how much you use is a direct appropriation that comes from the state engineer's office. And it's the laws of the state of Wyoming. So there's some really questionable things about this. And in addition to that, it makes it a criminal offense if you don't get a permit and if you don't permit your well. And so they can fine you. And then it goes on to say, we can take your water rights away if you don't get a permit. I mean, the ordinance is quite extraordinary and clearly, in my mind, unconstitutional. And to address the good concerns of the representative from up in Bighorn Basin, I agree with you. I could have made this thing a lot broader. I just wanted to solve one problem at a time and address this simple issue with a help the UW, who we just happened to remove over $40 million out of their biennial budget to save them $200,000 a year. So constitutionally, this is the right thing to do, and the ordinance was not. And I would suggest that if you live in the city and you have a water well, you would want this, you'd ask someone to come, a legislator, come and help bail you out, because I think their actions are unconstitutional.
Chairwoman Flintner.
Thank you, Mr. Chairman. I just want to ask the good chairman, I'm curious about these dollar amounts. It's astounding what was paid to the city in 2020 in water fees. And I'm looking at the percentage increases. Was that just to the university, or were those percentage increases across the board for everyone who used their municipal water?
So I had
Chairman Nicholas.
Oh, thank you. Sorry, Mr. I had a text message from the UW that said that those percentages may be off. And I meant, and I don't know what they are, but I can tell you that the city provides a discount by volume to the University of Wyoming. But I don't know what those rates are. The increases have been for local folks in town. My guess is that because, they just started charging UW in 2007. And so that exponential rise obviously wasn't for the every mom and pop in the town. What's important, I think, of those numbers is that even with this bill passing, UW is still going to pay 1.5 million per year, and those rates will be subject to increase however the city so chooses. And so if the city really wants to be retaliatory, they can raise up that potable water rate. And it's kind of a tough tug of war between the city and the UW, but it happens to arise on occasion. And the other important thing I think that you have to understand on the constitutional basis is UW is a constitutional entity. So it's like a state within a state, if you will, to have UW in the middle of the town of Laramie. It has its own rights and can control its own processes by the Constitution. And so there's always a tug of war between what the rights are of UW versus the city. And sometimes they bubble up to the head like this one too, but most of the time I think they get resolved. But this is just one that they said this is a bridge too far. So.
Minority Floor Leader Connolly.
Thank you, Mr. Chairman. So first, friends, let me tell you that this is a bill that is wanted by my employer. All right, so I've got number one, this is wanted by my employer. Number two, it's hated by the city that I love and call my home. So I'm just putting that out to start with, right? And also know that this has been an issue for half a decade, going on a decade. And honestly, in my mind, this is just another kind of knife in, right? We're playing chicken with switchblades right now. And this is just the next step. That's where I grew up. So we were talking some about the Constitution and the rights regarding water. There's another element of the Constitution, which is Article 3, Section 37, that says that the legislature shall not delegate any power to make, supervise, or interfere with any municipal improvements, monies, property, or effects where, et cetera. Right? You could make the argument that this is that interference. So what I am going to really ask of both parties, neither of whom I'm seeing in the gallery, but that they get together before third reading and they figure this out once and again, right? The city of Laramie honestly cannot lose going on $250,000 that it gets for the water that is being supplied this year, right? That is just a hit that can't be taken. And I honestly think that's what this is about. Right? It does save the university, who again wants and needs that money, but a compromise has to be made. And I don't think this bill is it. So I am going to very much and very firmly ask those parties who hopefully are listening to sit down and figure this out before third reading. Thank you.
Representative Stivar.
Thank you, Mr. Chairman. The question, page 2, line 5, connecting a building. We're connecting non-potable water to a building. I just need that explained.
Vice Chair Duncan.
Thank you, Mr. Chairman. So help me understand. I believe this is a pay me now or pay me later situation. We're paying the university's expenditures for the most part as we legislate and appropriate. So as expenses rise and we have to pay their utility, they have to pay their utility bills. So in essence, we're paying their bills, or they pay their own bills through having this well and having lower bills, and we have to appropriate less, so we don't have to pay as much or appropriate as much. Do I understand this correctly?
Chairman Nicholas.
Thank you for the first speaker. So a well house is a building, and a barn is a building, an outbuilding where your tool shop is a building. And if you have to run your sprinkler systems through those things, you need to hook it up and move it on. The language may be broader because at one point in time, you may recall, potable water was in there. And so the need to hook up to a building or facility is less imperative at this point. But remember, the UW is a private landowner. And why in the world can't they, as a private landowner, drill a well and use the water for their own good? I mean, that beneficial use, that's what it's for. What, if you read the ordinance carefully, what the city is trying to do is control the use of the aquifer for their own benefit and take away the private personal benefit from those other users. And that's really what this is. It's a run at the aquifer. To address the most recent question, UW has a budget. And if they can spend less money on irrigation and more on students and more to help cover the cuts that we impose upon them, this is the second round of cuts to them in the last 3 years, they can run a better run and provide more services and also keep tuitions down and make it a cheaper experience. So it's just another way, a cost-cutting measure for the UW.
Anyone else? Question? Representative Sherwood.
Thank you, Mr. Chairman. I debated on whether I was going to speak to this, but the university and the city are both in my district, and I want to look out for the best of both institutions. But what it comes down to is that this is a hot mess. And I'd love to say like, guys, you need to go hug it out. But I don't know that I think we're beyond that. So I have my personal opinions about the way this should go, but I want to ask the body, are we comfortable taking on the role of legal representation for the university in this matter? Are we willing to play counselor in this matter? I would prefer that we vote no and let the city and the university continue to work it out. Thank you.
Representative Sweeney.
Thank you, Mr. Chairman. So I guess my question to the bringer is, does he really feel we've explored all the avenues with the good city? And truly, will we still purchase will the university still purchase water in the long term, not in the short term, from the good city? And are we really being a good neighbor with all of this?
Representative Gray.
Thank you, Mr. Chair. I really urge a no vote on this bill. I think that the university's continued efforts to become a city within a city are not fiscally responsible, nor are they in line with what our state can do. I mean, you can see in this narrative, one thing that's left out is all the appropriations we've made for the wells, the dry well, not to mention this property acquisition. You know, they say they're going to save $200,000 from this, but $200,000 per year. But I can tell you that's not going to be taken out of state aid, that's for sure. But in the meantime, we've paid for all these wells, this property, or they paid for it using state aid, either as a buffer or directly. And this city within a city approach, it's going to hurt Laramie. And by the way, one thing I was hoping to say, I was going to use our privilege for it. We can say place names. I know there's been a little confusion about that. We changed that rule. It's going to hurt Laramie if we do this, and then they're going to come and ask for more state aid. And I can guarantee you the university is not going to ask for less with their $200,000 of savings. So let's vote no on this. It forgoes more expense for the state. And I just think the city within a city approach, it's not efficient, nor is it a good policy. So thank you.
Representative Knapp.
Thank you, Mr. Chair. I would urge a no vote on this as well. This is not uncommon in all of our cities. When you look at annexations and water and improvement districts coming into the city, there's disagreements on costs, there's disagreements on quality of water, but ultimately, when you become part of a city, you have those agreements that are built with the city for water. And UW is no different. We may fund them like a city, but they're not one. Up in my own county, for the golf course, we actually drilled wells and built a reservoir. But we came up with a creative way to give that water to the city and got credits back for that water. Water is a valuable resource, whether it's potted or unpotted. And so I would encourage those two entities to come up with an agreement rather than give them more power and authority. Thank you.
Representative Larson.
Mr. Chairman, thank you. I guess I have a question for the bringer of the bill. The permit for the wells that I think there's just one maybe that's drilled, two. Are they permitted for just irrigation, or do you know? And that may help me on how I vote, that it isn't going for potable, and I know that's taken out, but that's still a concern.
Chairman Nicholas.
So thank you, Mr. Chairman. To answer that last question, the water obviously can be used for any beneficial use up to a certain amount of the amounts. UW has agreed to amend the statute to make sure it's only for non-potable water, so it'll only be used for irrigation. And so I think that addresses that issue. I just want to have a brief discussion about the difference between the city and UW. Of course, UW is a constitutional entity and cities are not. If you look at, I think it's Article 7, Section 17, it says the Board of Trustees have all the powers necessary and convenient to manage the university. And so this is simply an exercise of that power. But what's more important is water law. The city of Laramie cannot dictate to the University of Wyoming that they cannot use their water wells to irrigate their golf course. And I think that's dictated by the state engineer's office and the Board of Control. And so if they drill a water well, now all of a sudden they can't use the water well. So that would be in direct conflict with what the Board of Control and the state engineer has authorized the university to do.
Vice Chair Larson.
Mr. Chairman and members, this conversation goes back, as the good minority leader pointed out, about a half a dozen years. It sticks in my mind, my first year in the legislature, there was a serious complaint by the city because the university was using so much potable water that it was a strain on their facilities. And so we funded, the legislature funded to go in. There was an existing well that was mentioned earlier to go in and rework that well and see if we could bring it back to life. That failed. So then the next year, because this was still a problem, we come in and we funded, and it might have been the year after that, we funded, as the was also mentioned, drilling some additional wells. We funded those wells. We funded the drilling of those wells with the intent to water this golf course. And now, now we're saying, no, we can't use that water. And which brings me to the second point that I'm just grappling with in this body is the private property rights thing that we really pound on all the time, that this is my land, the water under it is my water, as long as I comply with what the state engineer tells me to do. And now you're telling me I can't use it for a legal and unlawful use. It's just because you don't want me to use it because of the revenue impact it might have on me. That's not my fault. And I'm just struggling to see why the university and take away the university. Let's just say that it's Joe or Fred that's trying to do the same thing. Maybe they've got a well just outside the city limits, want to water a half an acre of pasture inside the city limit. They couldn't do it. That just doesn't fit. And so I encourage an aye vote on this. This just kind of goes contrary to what I think we normally support in the state.
Majority Floor Leader Summers.
Mr. Chairman, thank you. And I got a question to the bringer. So I could understand if the charge was like a right-of-way, so some kind of right-of-way charge, you could have a ditch and have to have a right-of-way, that sort of thing. But if this is just a straight charge for water that we own, the people of Wyoming, to a degree through UW, an institution of Wyoming. So if this is water we own and we can't get it to our property and it's all over across our own property, I don't know, maybe it crosses other town property or somehow we need a right-of-way. I could understand the purchase of a right-of-way, but I could not understand if this is a charge for gallons of water. It doesn't make sense. It's not the way you transport or do water. And so just clarify that to me. Is this a right-of-way thing or is this just a straight up charge? Because if it's a straight up charge, I'm on and for the bill.
Thank you, Mr.
Chairman Nicholas.
Well, it's the equivalent to not really a charge. It's basically a prohibition. They don't even want money because this goes from UW land to UW land. And so it's just denying the use of UW for its water from its land onto its other owned onto its own land. So, so why bring this bill? I mean, I would always be a person that says, sit down and face to face and resolve this, has been discussed. There have been discussions about this since 2007. They have been battling back and forth so much to the degree that, but last year, the chief executive held a mediation between the parties, and that was last fall to try to work this out and do it in a, do it in the old-fashioned way, and that was unsuccessful. A bunch of demands were made from one side, other demands on the other side, and nothing became of it. And so I think they've walked this line for 10 years now, and it's what does this do besides validate the right to use your own water on your own land, which is really what this does. But in addition, this just stops a lawsuit that continues this fight to go a lot longer. And frankly, as an attorney, I don't have any doubt who's going to win that lawsuit. But we just want to save everyone the money and the grief right now and get this resolved.
Representative Jennings.
Yeah, thank you, Mr. Chairman. So I never thought I would be back up here talking about the Jacoby Golf Course once again. I thought for sure that was done 5 years ago. But you answered a lot of my question, but did the university think about just hooking it up and let them sue you? I mean, I'm pretty sure you'd have some pretty good references for lawyers. And I mean, because it seems very clear in the water rights side of this. And so did that ever come to the discussion table? Well, we're going to run out there with 3 of our guys and we're going to hook this up. Or are they having to go across to other people's property?
Chairman Nicholas.
Thank you, Mr. Chairman. So the answer is yes, and they are in the process of doing that. And the answer is no, they don't have to go across anybody else's property.
Anybody else? Question being called. All those in favor of Chairman Nicholas's motion, when the committee of the whole rise to report, do so with the recommendation that House Bill 198 do pass. All those in favor, say aye. All those opposed, say no. Chair is in doubt. All those in favor, please stand. $36. House Bill. The bill passes. House Bill 198 has passed the committee of the whole. The next bill for our consideration is House Bill 217. The reading clerk will read the bill.
House Bill 217, sponsored by Representative Wilson. Community Health Center and Rural Health Clinic Grants, an act relating to public health and safety. Mr. Speaker, your committee number 10, Labor, Health and Social Services, to whom was referred House Bill 217, Community Health Center and Rural Health Clinic Grants. Respectful report, same back to the House with a recommendation that it do pass. Ayes. Representatives Clifford, Connolly, Flitner, Hallinan, Ottman, Romero Martinez, Stivar, Wharf, Wilson. Representative Hallinan, Vice Chairman.
Chairwoman Wilson.
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that House Bill 217 do pass. There are no amendments, and I will turn over the explanation to myself. So members, I hope this will be a lot easier than the last one. And the first thing I just want to point out, if you're looking at the bill, because it says Community Health Center and Rural Health Clinic Grants, I just want to tell you that there is no appropriation in the bill. There are no grants contemplated. That's just sort of an appendix from a previous statutory word. So no fear, no money. Okay, so let me just explain the origin of this bill. Way back in May, when after we had our special session, you remember during the special session, those of you who are here, we ran some bills enabling the group of statewides to look at applications for federal money on how to disperse it. And then after that, the interim committees it was asked of us that we come up with bills for a potential second session, which never happened. But that's really the origin of this. The thought of the Labor Committee at the time was that there was an existing program in statute, this program, which had not been funded in quite some number of years, but the function of the original program from 2011 was to funnel grant money to primary care and rural health clinics, basically with a focus on low-income people around the state with a sliding scale. And as I say, it hadn't been funded, but we thought that would be a great way to funnel some of the money to rural and community health programs. In the course of looking at that program, the existing language in statute, we noticed that the program sunsets this summer. So that was the first, and as I say, the second special session didn't come about, but we want to do three things with this bill, and I will walk it through, but there's basically three functions. The one is to delete the sunset clause, and that is so that if we ever get rich again, I don't know if that will happen or not, but if we ever are rich again, we could give grants from the general fund. We're not doing that now. Two, you can funnel federal grants through the program. And three, and frankly, even more importantly, there are a lot of private foundations out there. I can't mention their names on the floor, but if you think about it, if you watch TV shows, specials on, lions or snowstorms or whatever, and they'll say this program was sponsored by the somebody or other and somebody or other foundation, right? Those kind of groups. They often give out large sums of money to, some of them have specific focus on rural health. So we want to delete the sunset clause so that this program continues to exist in statute as a funnel for potential funding in the future. Second thing that we're doing is the original statute from 2011 said, and if you look at the bottom of page 1, you can see the title of the existing statute. It was for capital construction and startup costs. And we said, we don't want in life only building of buildings. So we have inserted equipment, and the idea would be that it will be really helpful to, maybe people will want a wheelchair ramp and an elevator, or telehealth equipment, ultrasound machine, that kind of thing. And then the third thing that we're doing in the bill, when we drafted the language originally in 2011, there's a number of restrictions in there. We are keeping the restrictions. The restrictions were only for the general fund money, or they're in the statute, but it seems to us that we can only really put restrictions on what private clinics can do with general funds. If your local community group wanted to donate, or a foundation wanted to donate, I don't see that the state can restrict how private organizations accept those funds. So we're just tidying that up so that the restrictions will continue to exist, but only for general funds. So if I can just real quickly, and I don't want to spend too much time unless people have questions, but the bottom of page 1, equipment costs is inserted into the title of that section. On the top of page 2, you'll see we added equipment costs. The underlined language on that first paragraph is just, tidying up really. You'll see that was paragraph A. Paragraph B is not in the bill because it continues to exist. That was the paragraph that creates the account to accept the money. C and D, you can see that in D, we are clarifying on line 17 that the restrictions are only for the state funds. And I can explain what the restrictions were if you want to know, but we're not changing the actual restrictions. Page 3, again, inserting in line 3 that there could be costs and equipment costs. And then line 11, there are 2 repealers. The first repealer, the D6, was a requirement that the clinics to get these grants prove that they fit under specific federal designations. The thing is that the statute was written in 2011, and all the time Congress comes up with new kind of federal names of things, and they all have acronyms and letters, and it seemed kind of silly to specify that and try to chase after whatever the feds might call it next. And then G is the actual sunset provision, which we are repealing. So I'd be glad to answer any further questions, but that's the gist of it.
Any questions? Question being called. All those in favor of Chairwoman Wilson's motion that when the committee of the whole rise to report it, do so with a recommendation that bill number 217 do pass. All those in favor, say aye. All those opposed, say no. I think that passes. House Bill 217 has passed committee of the whole. The next bill for consideration is House Bill 190. The reading clerk will read the bill.
House Bill 190, sponsored by Representative Brown. Vehicle titles for non-resident owners, an act relating to vehicle certificates of title. Mr. Speaker, your committee number 8, Transportation, Highway, and Military Affairs, to whom was referred House Bill 190, vehicle titles for non-resident owners. Respectful report same back to the House with the recommendation that it do pass. Ayes, Representatives Baker, Brown, Burkhart, Burt, Obermueller, O'Hearn, Stibar. Noes, Representative Henderson, McGuire. Representative Burkhart, Chairman.
Chairman Burkhart.
Thank you, Mr. Chairman. I move that when the committee of the whole rise to report, it do so with a recommendation that House Bill number 190 do pass. There are no standing committee amendments, and I turn explanation of the bill over to the good representative from here in the capital city.
Representative Brown.
Thank you, Mr. Chairman. Well, ladies and gentlemen, especially the newer members, I felt really bad that we couldn't do a license plate bill this year. So I got us as close as we possibly could, and I decided we would go ahead and talk about vehicle titles. So I bring you House Bill 190, and ladies and gentlemen, what this is actually a pretty simple bill. This is some clarifying language for a couple of county attorneys and a couple of county clerks in our state that have some language issues with the way our current statute reads about non-residents titling vehicles in this state. And so let me give you a little bit of a quick backdrop of what happened here. We have a company who likes to, let's say they pump oil, and they have a whole bunch of trucks that they buy, maybe in the Midwest, and they buy them in a fleet purchase, and they need to deliver 10 of them to the state of Wyoming for some of their people. And so they deliver 5 of them to Casper, and they deliver 5 of them to Cheyenne. Well, the 5 of them in Casper go down to their county clerk and their county treasurer. They pay their license plates, they pay their sales tax on it, and the dealership that's there inspects the vehicle and does a courtesy delivery. It actually costs the dealership a little bit of money to do this because they're actually doing the delivery of the vehicle and they're not making any money off the vehicle. They didn't sell it. They're just delivering this. So in Natrona County, this works perfect. Well, they come to Laramie County and the clerk says, well, you're not a resident. The state statute says you're not a resident of the state of Wyoming and you're not registered with the Secretary of State as a business because Company A, Oil Company A, actually resides in, I don't know, Oklahoma, let's say. And so they're not a registered agent. They don't actually have a business here. Their people are here moving in and out. So they needed to register their vehicle. So what do? They drive to another state, they license their vehicle, they pay their sales tax, and everything goes to another state. This bill fixes that, ladies and gentlemen. What this does is it says you can license and title your vehicle here as a company, and you can pay us all the sales tax you want. You can pay us all the license plate fees you want, and we're okay with that. So that's all we're doing here, ladies and gentlemen. If you look at page 1 and page 2 of the bill, it literally just says any person who operates a vehicle in the state of Wyoming that is not registered as a business in the state of Wyoming may register their vehicle in the state of Wyoming. And with that, I'll stand for any questions.
Representative Yen.
Thank you, Mr. Chairman. I'm wondering if we consider charging the non-residents even more than we charge residents. Thank you, Mr. Chairman.
Representative Brown.
Mr. Chairman, that was not at all even considered, and I don't believe that we can do that. I believe there's an equal protection clause in the Constitution.
Anybody else? Question being called. All those in favor of Representative Brown's motion when the committee of the whole rise to report it, do so with the recommendation that House Bill 190 do pass. All those in favor, say aye. All those opposed, say no. I do believe that passes. House Bill 190 has passed the committee of the whole. The next bill for our consideration is House Bill 125. The reading clerk will read the bill.
House Bill 125, sponsored by Representative Newsom. Simulcasting, an act relating to pari-mutuel wagering. Mr. Speaker, your committee number 2 appropriations, to whom is referred House Bill 125, simulcasting, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Larson Lloyd, Nicholas, Schwartz, Stiff. Noes, Representatives Kinner, Simpson, Walters. Representative Larson, Vice Chairman.
Vice Chair Larson.
Thank you, Mr. Chairman. I move that when the committee of the whole rise to report it, do so with recommendation that House Bill 125 do pass, and we turn over the explanation to the bill to the wonderful representative from up in the land of Cody.
Representative Newsom.
Thank you, Mr. Chairman, and thank you, Vice Chairman Larson, for that nice introduction. As you know, times have changed in the horse racing industry. There is no longer a barrier to gambling on horse races. In fact, with legislation just passed through this House, we'll be able to bet on live horse racing anytime from your phone. The 100-mile rule is out of date and is trying to be used to reduce competition in the off-track betting business. So you each have a handout. I handed you out kind of a synopsis of the archaic language that's being used in this simulcasting language that I have to be repealed. So today, most of the business to support live horse racing comes from the off-track betting facilities and the historical horse race gaming machines. These machines are what generate the money for live racing and have generated millions. So if you turn to page 2 of your handout, the back of page 1, you'll see a historical rendering of what's happened in the last 10 years with the horse racing. And you'll notice the Breeders' Awards are those awards that actually go to horse racers, to people who own horses. And those numbers have gone up consistently throughout the years. And in 2018, $2.3 million was awarded to these people that are actually raising horses. The bulk of that comes from the historic horse racing machines. So as you look at the next page is the income to the counties and cities. For those counties and cities that have approved historic horse racing, have approved pari-mutuel horse race gambling. And those are that's the income that's come from those machines and from simulcasting, as well as from live horse racing in those venues. If you turn to your back page, you'll see that what the 100-mile rule entails. When the statute was enacted, it was thought that people wouldn't attend live horse races if you could bet on simulcast races at off-track betting establishments. I don't think this is true now, and I'm not sure it was ever true. Live horse racing is more of a social experience. People go to live horse races that would not otherwise bet on simulcast races, and those that prefer simulcast betting have plenty of opportunity to bet online or at off-track betting facilities. The attendance at live horse racing has been increasing every year. Betting on live horse racing is not the main revenue source for supporting live horse racing in Wyoming. The revenue from historic horse racing machines is the biggest contributor, not only to the live racing subsidy, but also to local tax revenue. Forcing the closure of certain off-track betting establishments during live races would negatively impact the racing industry and local tax revenue. So as we walk through the bill, it is really long and arduous, and I'm so sorry for that. but being the queen of one-word amendments, I thought this was appropriate. So just on page 1, it just repeals the 100-mile simulcasting provision from 1125-102A 7C. And I'll stand for any questions.
Any questions? Oh. Any questions on committee of the whole amendment number 1?
Mr. Chairman.
Oh, excuse me. Speaker Barlow.
Thank you, Mr. Chairman. So we're on the bill. Is that my understanding, Mr. Chairman?
My apologies. We are on the bill. Speaker Barlow.
So thank you. So I guess I wanted to understand maybe better the archaic language, because I think I was here when this law was actually enacted. Which, I mean, I have turned gray in the last couple of years, but I don't know that it means it's something archaic. So I guess what I would like to understand is what is the context of the simulcasting in reference to the different licensures or the permits that are required? Because my understanding is you have to actually have a permit to run live horse races before you can get a permit to have simulcasting and the machines that you put your money into. So tell me I would like to know, Mr. Chairman, the hierarchy of priorities in the current statute, and where and why and what the bringer of this amendment or this bill thinks, why they think it's different now than it was. I think that's only 6 years ago, maybe, archaically time, in glacial time, 6 or 7 years ago. So I would like to understand what that is, and I would like to understand if and when this 100-mile rule, which is statute, has it ever been applied, and if not, why not? Thank you.
Vice Chair Newsom.
Thank you, Mr. Chairman. The 100-mile rule has not been being enforced. And that was one of the things that kind of brought this to the forefront of my idea to repeal this. So it has not been being enforced. It is the hierarchy of permits is you have to have a live horse racing permit. There are permits in Rock Springs and permits in Evanston, and formerly there have been permits in Gillette. And if you have a live horse racing permit, then you are allowed to have historic horse racing and off-track betting facilities. And those can be in any county that has approved parimutuel wagering, which includes communities and counties that do not have live horse racing, such as Natrona County and Sheridan County, have approved parimutuel betting, but they do not have live horse races. But the permittees that run live horse races are allowed to have off-track betting facilities in those counties.
Vice Chair Duncan.
Thank you, Mr. Chairman. And that was enacted in 1988.
Representative Stiff.
Mr. Chairman, on and in support of House Bill 125. So as the sponsor has already explained, current law allows a new live horse racing operator to effectively hold other permittees who have, say, historic horse racing machines and are doing simulcasting, to hold them hostage, right? During the days that they race. And so it's as though you had a law. It would be like if we had a city ordinance that said, or a state law that said, because we want to promote live theater, that if live theater is occurring in a city, that no movie theater would be allowed to broadcast or be open within 100 miles of this live stage production of live theater. And so I think we all recognize just how absurd that would be. And as a result, the current law, which artificially restrains commerce, artificially restrains trade, and frankly potentially hurts local tax revenue, needs to be repealed on and for.
Vice Chair Duncan.
Thank you, Mr. Chairman. I need to clarify. I'm sorry. The 100-mile portion was enacted in 1988. Historic horse racing passed in 2013. So, and to reiterate, the reason why was to reiterate what the previous speaker just said.
Chairman Gurr.
Thank you, Mr. Chairman. So I just gotta make sure I'm clear. So I look at the map with the circles and, it's not my district, but Hot Springs County has this wonderful equestrian events. I mean, they had a lot of snaffle bet competitions and ropings, and I could see them having live horse racing at some point in time. And if that were the case, then they wouldn't be able to do any coordination with offsite betting unless if there was any overlap. Okay, so they could only just pick up the crumbs around there. Is that as the law exists today? Am I understanding that correctly?
Yes, the best
Through
example.
the chair,
I'm
Vice
sorry.
Chair Newsom. Vice Chair Newsom.
Thank you, Mr. Chairman, and sorry. The best example of this is currently at the racetrack in Gillette. If you look at that circle, it encompasses Sheridan County as well. So although there is no economic benefit of live horse racing to Sheridan County, they would be negatively impacted by not being able to run off-track betting while those live horse races are going on. So that's a real life example of what could happen if the operators chose to have this rule enforced. So you could affect Sheridan County, which has no economic benefit from live horse racing, while Campbell County does have benefit from live horse racing. So Sheridan is negatively impacted.
Representative Simpson.
Thank you, Mr. Chairman. Members, when this bill first came to me, I was interested to know what the impact was going to be to the owners of the horse races, because as we all know, this is all about the racing and the horse owners. And so I've done a lot of research on that, and I direct your attention to page 2 of the handout. For your information, as you go down the left-hand side, notice the word Breeders' Award in each of the categories. That is the payouts to the owners of the racehorses. That's what it's all about. They receive extra money and rewards for having studs, for mares bringing colts along and racing them in the horse races. And to my best determination, this bill does not hurt our breeders and horse owners. They're going to benefit. They benefit from every direction, whether they're live or whether it's simulcast. Again, live or historic, it still has a nice payout for them. And so I just thought that would be important for you to know.
Oh, Chairwoman Wilson.
Thank you, Mr. Chairman. Just one last thought, though. So the only thing is that the discussion about how if we don't pass this bill, people are harmed financially, that might be, but that's only if you can, to my mind, that's only if you consider having lots of people sitting in kind of dark rooms, pressing buttons and making ringing noises a good thing. Maybe someone could just clarify why I don't want to vote no, because I don't really want more people sitting in rooms, in dark rooms, pressing buttons with little flashing lights and ringing noises.
Vice Chair Newsom.
Thank you, Mr. Chairman. The people sitting in dark rooms pushing buttons are the ones that support live horse racing the most. If you look at your chart, you will see under historic horse racing that is the biggest contributor to the Breeders' Awards.
Thank you,
Representative
Mr.
Walters.
Chairman. At this time, I'd like to move Committee of the Whole Amendment number 1 to House Bill number 125 and ask for your favorable consideration.
Point of order,
Vice Chair Newsom, state your point.
that it does not comply with the intention of the bill. The intent of the bill is to repeal. It is not to amend.
Vice Chair Newsom, are you calling a Rules Committee on germaneness? Rules Committee being called. Please approach the dais. Members, the chair, after consulting with the Rules Committee, has determined that the amendment is germane to the bill at hand.
I object.
Vice Chair Newsom, are you asking the body to overrule the chair?
Yes, I am. Thank you, Mr. Chairman.
Pursuant to House Rule 5-5, the chair may be overruled only by a recorded majority of the committee membership. Says right here. Yeah. We're going to start with the standing division. All those, if you're voting aye, that means you are agreeing with the ruling of the chair that it is germane to the bill.
Point of order, Mr. Chairman, I believe it is debatable.
It's not debatable. Stand at ease.
And so, Mr. Chairman, because it is debatable, I think we ought to at least allow the objector to provide her objections, and the body can debate the objection and overruling the chair if they so desire.
The chair has ruled that it is debatable. Vice Chair Newsom.
Thank you, Mr. Chairman. When I brought this bill, my intent was to repeal this provision in the statute. My intent was not to amend it. If I had intended to amend it, I would have brought in a different bill to the body. So the original intent was to repeal this provision. Thank you.
Anyone else? All right, pursuant to House Rule 5-5. Oh, Chairwoman Wilson.
Thank you, Mr. Chairman. Sorry to be slow. I didn't bring my Mason's book up to the front when I brought it, but it does say, and we don't have to necessarily do that, but it says, to be germane, the amendment is required only to relate to the same subject. It may entirely change the effective or be in conflict with the spirit of the original motion and still be germane, sadly.
Majority Floor Leader Summers.
Mr. Chairman, thank you. So while I don't think this is germane, I don't believe I am in favor of overruling the chair. So I kind of go with the will of what was in the Rules Committee. And so to me, I don't want to overrule the ruling by the chair. So I will be a no on that.
Anyone else? Representative Yen.
Thank you, Mr. Chairman. So I want to just give some information and context on what the ruling is and what overruling the ruling means and what we're arguing in the first place, right? So we're trying to determine if the amendment is germane to the bill. So the bill has a bill title. On this bill, it's lines 1 through 5. And we're determining if the amendment, which describes clarifying what the 100-mile rule is germane to a bill that is a repealer. We did get some advice from LSO. I mean, if another member wants to bring up that advice, it's fine. But I do want to point to what Masons describes as what is considered germane. It's section 402 in Masons. If you do have a copy of Masons, I highly recommend getting one if you don't. The good chairwoman of Labor and Health said it succinctly, but it does describe 1 through 5 on what makes an amendment germane. So I would just look over that real quickly before you make a ruling of the chair. And I'll read number 1, which is every amendment proposed must be germane to the subject or the proposition or the section or the paragraph to be amendment. So the question is, again, for you guys, is clarifying the 100-mile rule germane to a bill that is a repealer. And some would argue that it is, some would argue that it isn't. In the Rules Committee advice, I said that I didn't think it was germane, but this is for the body to decide. Thank you, Mr. Chairman.
Speaker Barlow.
Thank you, Mr. Chairman. So I think there probably needs to be a little more discussion on whether we're talking about a germaneness issue, which is a rule issue, or we're talking about the title of the bill and the topic of the bill, single subject. And I think that there's no, I mean, in my view, there's no question it's germane. We're talking about that limit. It's the same topic. Now, is the change within the bill title, are we talking about the same change, the same piece of statute being changed? Is it within the scope of that change? Now, for those of you who didn't hear the discussion at the front, and I know there was many of you up here, the discussion was, is it from 0, which if we repeal, it'd be 0, correct? It's 100 in the current statute. Would be going to 200 be beyond the scope of the bill? Would be going somewhere between 0 and 100 be within the original intent and scope of the bill? So that, I think, is the question. The germaneness, certainly it's about the same issue. It's, in my view, it's about the same issue. But it's the scope of the bill. Have we gone beyond the original scope of the bill for this 100-mile simulcasting prohibition, et cetera? If you think that this goes beyond the 100 miles and adds more restrictive things or greater latitude, then you should vote apart from the chairman. If you believe it's within the 0 to 100 and clarifies, then you might come to the conclusion that it is within the intent and scope of the bill. So I hope that clarifies it. Germaneness, in my view, is not a part of this discussion. It's the title of the bill, whether this fits within that title. Thank you, Mr. Chairman.
Representative Duncan.
Thank you, Mr. Chairman. So a deeper dive question for me, and I'm stuck on it, so I don't know if that's part of the germane part or not. Can you amend a repealer?
Anyone else? Question being called pursuant to House Rule 5-5. Standing committee vote will be required. Again, the chair has ruled that the amendment is germane. So when I say call for the ayes by a standing vote, you stand, that means you are agreeing with the chair. When I call for the noes, that means you do not agree with the chair. Got it? All those who agree with the ruling of the chair that the amendment is germane, please stand. Thirty-three ayes. Those against, please stand. Less than 33. So now that the amendment has been ruled germane, we are back on the amendment. Committee of the Whole Amendment number 1 to House Bill 125. Representative Walters.
Thank you, Mr. Chairman. And before we started into our parliamentary procedure exercise there, I had moved the amendment, Committee of the Whole Amendment number 1 to House Bill 125 and asked for your favorable consideration. And what this does is really put some clarifying language on what is a premises. So the commission that regulates these and the county commissioners as well are part of the regulating body. They regulate 2 types of premises. They regulate the premises that has the off-track wagering facilities, the machines, and they also regulate the live tracks. And so this 100-mile rule conundrum really comes into effect in a community where you have 2 different operators with off-track machines operating. And I would offer in some communities, they have 2 different operators offering the machines plus one of those operators offering the live racing. And so this clarifies The machines are different than the live racing. This 100-mile rule is in effect for the live race component of simulcasting. And I do this in an attempt to continue to try and get people to go to the live horse races. We can see what the revenue is generated and has grown over time on historic racing, yet the number of live race days have not increased in the last 7 years, at least not substantially. And so just trying to keep live racing at the forefront of our horse racing activities. And that's why I would rather amend the statute than just wipe it off the books altogether. So with that, I would take any questions.
Chairman Gurr.
Thank you, Mr. Chairman. I rise in opposition to the amendment, and I appreciate the sponsor of the amendment saying I'm just trying to define premises, but you may be. But the simple fact is you're just completely eliminating the intent of the bill, which the intent is this 100-mile restriction. And you're keeping that in place. And, you know, when you look at how those circles work on the map in Wyoming, and you realize the mountains and the canyons and the valleys, and maybe, I know I'm not the only one that lives surrounded by those items. You are not opening up the opportunity for this industry to be able to grow and to be able to start up in different areas. And in my opinion, this is not an industry where building a fence is even good for its own industry. Quite frankly, there are many examples where people may think that building a fence is good because it eliminates competition and brings and creates a captive audience. It's not the case here. This is a form of entertainment. People travel to entertainment, and people travel to locations where there are more and more points of entertainment. And so we have talked already about Sheridan, one of the best rodeos in the world. I know people in Cheyenne will argue with me, but still, what a wonderful event. Again, I talked about even locations in the Bighorn Basin, and we're really being precluded from even having the opportunity to grow and move into this industry. And what this amendment does is says, you're not gonna be able to. So if you vote for the amendment, you know, the initial bill means absolutely nothing. So I'm a no vote. Thank you.
Vice Chair Duncan.
Thank you, Mr. Chairman. I'm 100% behind my chairman. He said it perfectly. I'm a no vote. However, I do have a question of clarification I would like. Does this shut down the OTBs year round or just during the racing dates? I am a no.
Speaker Barlow.
Thank you, Mr. Chairman. So I always like it when somebody brings up the fence analogies. You know, this is where I've come from and what I grew up doing. You know, they say good fences make good neighbors. Well, that's actually not true. Just good people are good neighbors. Because no matter whether your fences are good or bad, you take care of each other, you take care of each other's livestock, you take care of things. And actually, that's probably what's going on here. People aren't taking care of things that need to be taken care of. There's a lot of money involved in this, folks. We talked about some of those bills we've already had with the video and different things. This is big money. And yes, there's a little bit of that going to live horse racing and a little bit of that going to the municipalities and counties, but there's a whole lot going other places. So this is a big deal. This is a really big deal. And it should be for those communities that have voted by county. You've voted whether you want racing in your county. Subsequently, simulcasting, subsequently, historic horse racing, because they're tiered off each other. You don't get the other two if you don't have the first one. At least that's the way it should be, correct? But maybe that's not the way it is. I will agree that the 100 years, the 100 years, but it feels like 100 years. What time is it? The 100 miles may not be the right factor. Maybe it should not be up beyond a county line. Because remember, each of your counties that voted for this, all of a sudden now you're being with this rule, if it were enforced, back to if it were enforced, it would impose one county's druthers or will on another county. And those voters would have said, wait a minute, we voted for this and now we don't have access to it. So when you look at those circles, I think the circles are problematic. And if this amendment proceeds, I'll bring a second reading amendment to say 100 miles, but not beyond a county line. Because there are several different levels of responsibility. Certainly there is the gaming commission, and then there is local county commissioners involved in this. And then of course there's the operators. And we start crossing lines, right? County lines. We start having these intersections of authority and intersections of authorization. So I do think that probably this amendment, the best thing about this amendment is it makes us talk about the entire issue. The entire issue. I kind of would like to see more horse racing. I'd kind of like to see, and I'd like the folks that want to do horse racing to get along. I'd like them to figure out that process. And maybe having this discussion on this floor helps do that. Do we get to the perfect solution with this amendment or with this bill? I don't know. But I think jettisoning this amendment and going with the bill gets us nowhere. Gets us nowhere because we can't get folks to the table. I think we heard that about a water bill not too long ago. We're probably going to hear about that, about a bill in the land of the Tetons not too long. Folks, come to the table and let's figure this out. Because these are communities, it's important to them, these are industries, and these folks are, yeah, they're taxpayers. But it's also the communities that voted for this type of activity in their community, and they're tiered. Horse racing, gotta have horse racing, gotta have a license to have a permit to have horse racing before you can do simulcasting, before you and the historic horse racing. So that is for me, that's the tiers, what you have to keep in mind as we go forward. I do agree, the 100 miles, yeah, there's a better place than 100 miles. There's a better place. I think far more nuanced than 100 miles. And if this amendment survives second reading, we can have a discussion about what that might be. Thank you, Mr. Chairman.
Majority Floor Leader Summers? Nope. All right. Representative Bear?
Thank you, Mr. Chairman. I am rising on and for the amendment, and frankly, I just cannot vote for the bill without the amendment. The reason being is I believe that this state is different from Nevada, and I hope to keep that. The whole intent of this particular statute was to keep live horse racing and to keep the equine sports alive, which need these funds from the betting, which I don't really approve of, but it's working. And I'm afraid that if we get rid of the 100-mile rule, I liked what the previous speaker just said about changing it, but if we get rid of it, I'm afraid we're going to lose live racing and we're going to be left with betting.
Vice Chair Larson?
Mr. Chairman, if you'll indulge me a little bit, because there's a component of this discussion that I need to get figured out, and I don't know if it's part of the amendment or part of the bill. But if the 100-mile radius is kept and the county votes to have a new live horse racing event come into the county, and the previous live horse racing entity has the historic horse racing machines there, does he get to keep his machines there? Or does the new entity, because we hear that they have, you have to, one's kind of dependent on the other. So if a new show comes to town, do you force that business that's been there for a period of time to take his machines outside the boundaries, whatever those boundaries are? I think that's part of the extended conversation. If I can get clarification, it would help me understand how this all works.
Representative Fortner?
Thank you, Chairman, or Mr. Speaker. I'm for the amendment, for the bill. I'm also for whatever makes Wyoming great as a whole. I know gambling is going to be the next gold rush for Wyoming. It's gonna create a lot of revenue. I think if the counties can't work together in an overlap situation on the 100-mile rule, I believe that we can work something out. I believe we have to, it's a must. I'm for the amendment for the bill. Thank you.
Majority Floor Leader Summers.
Mr. Chairman, thank you. And I'm on and against the amendment. This isn't the solution. And so if there really needs to be a second reading amendment, maybe we ought to see what that is and see what the real solution is. But this still leaves the fence in of 100 miles and the overlaps. And so I'm on and against the amendment.
Vice Chair Newsom.
Thank you, Mr. Chairman. I'm on and against the amendment. It was not my intent bringing this bill to clarify or change the existing statute. My intent was to repeal it. Thank you.
Representative Worf.
Thank you, Mr. Chair. In support of the bill against the amendment, for some of the comments that have already been made, I do think we need to repeal the 100. And if there's something else to be brought forward, I think that's fair. But I just don't think the amendment's good. So on and against the amendment for the bill. Thank you.
Any other members? Representative Walters.
Thank you, Mr. Chairman. To answer a couple of the questions, one was asking about the OTB and are they shut down all year or during the day of the race and whatnot? And this amendment would not affect how the commission is currently handling those activities. And then I would just offer some thoughts on fencing in or fencing out. And I would say the existing language already offers the opportunity for growth in this business. And that is because if you look at the amendment starting on line 24, it says, except that the commission may waive the 100-mile rule limitation if the simulcast permittee application includes written approval from the permittee whose permitted live horse racing track with the amendment premises is within that 100 miles. So all somebody has to do is go to the other person within that 100-mile circle and get permission, and then take that permission to the commission and say, look, we've worked it out. So there's plenty of room and opportunity for growth. It does help to, this amendment, as I start out saying, helps to clarify that when we're talking about premises, we're talking about the live tracks, not all of the OTB locations. And I think it's a good approach to start correcting some of the confusion within the statute versus just throwing it out. And so I would encourage an aye vote on the amendment, and thank you for your time.
Question being called. On Committee of the Whole Amendment number 1 to House Bill 125. All those in favor, say aye. All those against, say no. That amendment has not been adopted. We are back on the bill. Vice Chair Newsom. Division being called on the amendment. Committee of the Whole Amendment number 1 to House Bill 125. All those in favor of the amendment, please stand. (19) All those against, please stand. More than 19. That amendment has not been adopted. We are back on the bill. Question on the bill. All those in favor of Vice Chair Newsom's motion that when the Committee of the Whole rise to report, do so with the recommendation that House Bill 125 do pass. All those in favor, say aye. All those against, say no. The ayes have it. House Bill 125 has passed the Committee of the Whole. The next bill for our consideration is House Bill 132. The reading clerk will read the bill.
House Bill 132, sponsored by Representative Walters. Casper State Office Building naming, an act relating to the administration of the government. Mr. Speaker, your committee number 2 appropriations, to whom was referred House Bill 132, Casper State Office Building naming, respectful report, same back to the House with a recommendation that it do pass. Ayes, Representatives Kinner, Larson Lloyd, Nicholas, Simpson, Stith, Walters. Noes, Representative Schwartz. Representative Nicholas, Chairman.
Chairman Nicholas.
Thank you, Mr. Chairman. I move when the committee of the whole rise and report, it does so with the recommendation that House Bill 132 do pass. I'll turn the explanation of the bill to the good representative from the middle of the state.
Representative Walters.
Thank you, Mr. Chairman. Members, I bring to you House Bill 132, and it is the naming of the Casper office building. And what this is, members, is it's a local control issue that we're discussing here. And so there's a skilled nursing facility being built in the north central part of the state that those folks in that community may want the opportunity to name. There's also the state hospitals had some new buildings built down in the southwest corner of the state. Those folks may want the opportunity to name that. The Life Resource Center in the central part of the state has some new buildings. And so what's taken place is when the funding was approved for the Casper State Office building, it was also approved with a task force. And that task force is made up of senators and House members, as well as local community members that have made the decisions for the Casper State Office building. This group came forward. They have mitigated issues with the high school that's right across the street. They have mitigated issues with the surrounding landowners and business owners in the area. They've picked out exterior colors. They've picked out design plans, floor plans, interior plans. That's what this task force has been working on for about the last 3 years. However, when it came down to the naming of the building, the task force came up with about a half a dozen names, narrowed those down to 2 really that rose to the top. And one of those 2, a private entity, and came to the task force and said, please don't use that name for the Casper State Office building because we intend to use that name in a private fundraising effort for a private building that's being constructed for the performing arts within our fine community. And so it left us with the other top member. As I said, there were 2 that were right there together. And so the other name that came forward is the name on this bill. And because the name is on this bill, I think I can use it on this floor, and that's Mr. John Wold. What happened is then there's 5 electeds that sit here in Cheyenne that decided they had a different opinion on how this building ought to be named. And they named it after an individual that was raised and grew up here in the fine community that we're in today and served the longest elected of time in state government. Mighty fine accomplishment, but I think that individual is more fitting of a building in this fine city than a building 250 or 200 miles north of this fine city. So what did Mr. John Wold do in his time in Wyoming? He lived about 70 years in Wyoming. As the old saying goes, he wasn't born here, but he got here just as quickly as he could. So he arrived in Casper in the late 1940s. He was a geologist. He was working for an oil company at the time. He started his own oil company in the early 1950s. He went on to discover and joint venture partner with the coal mining operations in the Powder River Basin. He also created and started the Trona mining ventures down in the southwest corner of the state, sold his share off to some of the companies that are still operating those mines today. And before he got to Wyoming, I think I should note his military career. He volunteered in World War II as a minesweeper following the attack at Pearl Harbor. Went on and did that. And then as soon as he was honorably discharged, as I said, he moved to Wyoming, spending the next 70 years in Casper. He donated tremendously financially to Casper and in Trona County, but to the entire state of Wyoming. He's done all of those things that I was discussing in the mining industry, the oil and gas industry. I would venture to guess that his companies have paid billions of dollars in severance and ad valorem taxes to the state of Wyoming. And then he went on to serve right here in this esteemed body in the Wyoming House of Representatives, followed by a term in the United States House of Representatives. He served on just about every professional board you can imagine related to mining, oil, gas, ranching, as a matter of fact, as he was a cattle rancher as well. And then he's also contributed philanthropically. He's donated not just money, but time to make sure that there was an extra sheet of ice for hockey and skating in Casper, creating and starting a ski area on Casper Mountain. And then just a couple little final points to point out. He was the oldest living Eagle Scout when he passed, and he was also the oldest past member of the United States House of Representatives at the time of his passing. And again, this to me is not about the 2 individuals that were selected. It was about how they were selected. So our task force was tasked with coming up with exterior, interior, all of the parts of this project. And yet our task force was simply ignored when the naming of this building came about. And as I said, the other individual that was named by those 5 folks that live here in this fine community is a wonderful individual. I just think it's more fitting that a building in this community where that person was part of the fabric of the community be named in their honor, and the person of John Wold, who was an integral part of the fabric of the community where this building is being built, be named in his honor. And so I would ask for your favorable consideration. I would gladly welcome any questions.
Chairwoman Wilson.
Thank you, Mr. Chairman. Just to add a little extra information, and of course, I'm somewhat handicapped by not saying the name of the person, seeing as the name of the other person's isn't in the bill. But I just want to point out that the other person that they were planning to name the building after, the building that was built with state money, was the first female Secretary of State in this state and served in that position for 24 years. So she held a statewide position. It's not like she was just some random person from this community. Just pointing that out.
Speaker Barlow.
Thank you, Mr. Chairman. So we've got other buildings to the north and the south of us that are named after other folks. I guess I'd like to know how those, what process was undertaken to name those folks, irrespective of what community they're in. If they were named after an individual and they're under the those 5 electeds that are responsible for the buildings and the grounds on behalf of the state of Wyoming and its citizens, how were those others named after former governors, et cetera, et cetera? Thank you, Mr. Chairman.
Chairman Zwanitzer.
Thank you, Mr. Chairman. I'd be happy to answer that question. They were named by the State Building Commission, the commission that's named every state building in the history of our state since we formed the State Building Commission, right? And they're all named after former governors, so half the way, the Hersler, the Hunt, the Emerson, the Barrett, right? This is a prerogative of the executive branch and always has been. And I think it's just very fair to say the executive branch has named this building. And it's not about the individual necessarily, but it does seem, I can't think of the right word, wrong for the legislative branch to come in and say, we don't like, who you named the building after. And so we, the legislature, are going to overrule you and in statute, which we've never done before, and that I can find in the history of Wyoming, in statute, name a building after someone, which is weird enough, but especially after the executive branch took 3 meetings of testimony and named it, right? With a public comment and multiple people coming in. And I can appreciate we had a task force that this body assigned that was supposed to pick out paint colors and yard work, but they were never, ever tasked with picking out the name for this building. They took that upon themselves. I'm not exactly sure where they found statutory or directive to do so, but it's never been their prerogative to do so. It has always been the prerogative of the State Building Commission. For the same reason the Constitution says we have a Game and Fish Commission. So this body doesn't have to decide hunt areas and quotas. Well, we have a Transportation Commission. So this body doesn't get to decide which projects go where in Wyoming and what the priority order is. Why we have a School Facilities Commission, because we have people outside the legislature get to make the decisions on which schools are built next. This is not a legislative prerogative, because exactly what just happened the last 10 minutes, where we'll come in and say, we need to name a building because this person is more worthy than this person, with a body of 90 of us, is just not right. And so I would ask you actually to resist the bill. I'm going to bring a committee of the whole amendment to bring the building's name back to what the executive branch has proposed here in a second. But to answer those questions, it's always been an executive branch prerogative, and I think it should stay that way.
Representative Duncan.
Thank you, Mr. Chairman. Sorry, I've been here a lot today. Sorry. The person who was originally named, there is not a single building, and we're just coming off on the heels of the Year of the Woman for the state of Wyoming. There's not a single building in Wyoming named for a woman. I'm going to use my woman power and my woman card here. So there's not a single state building named for a woman. We just celebrated a big date, a birth date, an anniversary for being the equality state, and we have no buildings named for a woman. the executive branch named a building for a woman, and then we arbitrarily go and decide, no, that's not good enough. We're going to give it to a man. No, doesn't sit well with me. Sorry. Sorry. I'm pulling the woman card.
Chairman Swanitzer.
Hey, with that, Mr. Chairman, let me move committee of the whole amendment number 1 to House Bill 132 and ask for your favorable introduction or not. But what this amendment does, ladies and gentlemen, is take it, and I do notice there's a spelling error. There's a Scrivener error. There is no P in the last name of Thyra Thompson. So let me do a quick technical correction from the floor, if I could, Mr. Chairman, and delete the P in Thompson on lines 2 and lines 5. I think I need a motion and a vote for that. If I could call the question.
Question being called on
Technical correction.
the technical correction, removing the P. On page 1, line 9, and page 1, line 11. All those in favor of committee of the whole amendment number 1 to House Bill 132, say aye. Those against, say no. That amendment has been adopted. We are back on the bill.
On the
Chairman-
amendment, Mr. Chairman. Thank you.
The
And so,
technical
ladies and
correction. Sorry.
gentlemen, if we are
Chairman
going to take,
Swanitzer.
thank you, Mr. Chairman. If we are going to take the step and put this in statute, which I would say we still don't need to do, I would put forth the name that would coincide with what the State Building Commission of our 5 statewide elected officials chose to be Thyra Thompson for the name of the building, and would ask for your favorable agreement.
Any discussion? Representative Walters?
Thank you, Mr. Chairman. I'm going to encourage a no vote on this amendment. Again, this comes down to picking someone that's the fabric of the community where these buildings are located. And while I think Thyra, and I think it can be said now because that's the name on the amendment that we're discussing, is a wonderful individual, did an outstanding job, served Wyoming extremely well. She was from Cheyenne and is deserving of a building that is recognized around Cheyenne here, not a building that is in Casper. And so that's why I would encourage a no vote. As to the executive branch picking this versus the task force picking this, you know, the task force issue is something that we in the legislature have taken up in the last few years, noting that it needs to have a little bit more of a local feel to it so that the locals know what's going on. And I'd also point out that the SBC does not have the statutory authority to name buildings. They have delegated this authority to themselves through their rulemaking process. If you read the statute on what they're allowed to do, I would argue it's pushing the bounds to even give them that ability. And so I think it's certainly fitting of this body to decide what the name of these buildings ought to be. And I would encourage a no vote because on this amendment, because it goes against what the local group felt was necessary and who was ingrained in the fabric of that local community. So again, I would encourage a no vote on this amendment. And the no vote is not because I don't find Thyra to be a viable person and a worthy individual. It's just not the right name for the community in which this building is being built.
Chairwoman Wilson.
Thank you, Mr. Chairman. I would ask an aye on the amendment, and I'm perfectly happy with a no on the bill. And no disrespect to either of the persons. They're both super individuals, but I would submit that a person who was elected to statewide office for 24 years is owned by the state, not by a specific community.
Representative McGuire.
Thank you, Mr. Chairman. And I'm going to pull the minerals card just a little bit. And by that, I'll just say, coming from the center part of the state and having worked a lot in the county where their camels are the mascot for the high school, you know, a lot of times the people who really built the state and paid for the infrastructure that we have are forgotten. And John Wold, without question, was one of the pioneers who brought in the mineral industry to Campbell County, period, end of story. And then after that, he took and went down to the Trona mines, and with Union Carbide, he had the first Trona mine down in the Green River area. And, you know, we keep forgetting about these people. And, you know, at some point, we kind of need to recognize those people who really did build the state. And Mr. Wold served in this house. His son served in this house. And then he served in the US Congress. And he was on virtually every board, every nonprofit in Casper. And, you know, there is something for a community tie, and really and truly, those who are in his industry have been, I don't know, maybe we just don't recognize them enough. So I would encourage a no vote to the amendment and yes on the bill. Thank you.
Madam Minority Floor Leader Connolly.
Thank you, Mr. Chairman. And Andrew, I just want to tell you that I had the pleasure of having lunch with I think it's your great grandma a couple of times, because she was such a supporter of UW and the students in the College of Arts and Sciences, that she sponsors an honors convocation once a year. I mean, just a wonderful, wonderful, generous individual. That being said, she was also a powerhouse in this state. 24 years she served as the Secretary of State at a time when few women, although we do have that great history in Wyoming, that she did. That she lived in Cheyenne because she was our Secretary of State. And the Casper office building, it's a Wyoming office building. It's where the state of Wyoming office is, not the city of Casper or the wonderful county of Natrona, but it's the state office building. So to me, it makes absolute sense that we honor a statewide figure. And Thyra Thompson is one statewide figure. I also just got a note that there is already a building in Casper named for Mr. Wold. It's the Wold Physical Science Center at Casper College. How appropriate. So on and in favor of the amendment, Thyra Thompson is so deserving.
Representative Rodriguez Williams.
Thank you, Mr. Speaker. On and against the amendment. I'm going to vote in favor of the World War II veteran. That was a minesweeper. As a granddaughter of a World War II veteran who was also a minesweeper, who just turned 95 years old, that's where my vote will lie.
Chairman's Wanitzer.
Thank you, Mr. Chairman. And I would submit to you the last 4 people testifying is exactly why we don't leave this to the legislature, right? Because we pull the women card, the minerals card, you name it, the veterans card. I mean, I don't know who has widows or orphans, but I'm sure we'll check the boxes. And vulnerable populations, thank you. And this argument that we don't name all the state office buildings in Cheyenne after people from Cheyenne, right? Barrett from Torrington, Hunt was from Riverton, Lander, Hathaway was from Torrington, Hirschler's from Kemmerer, right? So I live in a city that has all of our state buildings named not after local Cheyenne or Laramie County governors. So I don't understand that argument. But I do understand the argument that the State Building Commission has, even if it's not in statute, the rule and reg since 1975, they have named the state buildings in the state. And if we're going to somehow say all of a sudden, we don't like what the executive branch is doing and it's now a legislative prerogative, I just think it's wrong. So I'm fine if we're going to start putting it in statute, state building names. I think it should be in Title 8 actually, where all the other state symbols are. But if we're going to name it, I would at least like to keep with the executive branch. They had 3 public hearings. They took a lot of testimony and time. I didn't want to get into this war. I'd ask you to support the amendment, probably still no on the bill. Thanks.
Question being called. All those in favor of Representative Walters' motion on the Committee of the Whole rise report, amendment, excuse me. We are on committee of the whole amendment number 1 to House Bill 132. All those in favor, say aye. All those opposed, say no. Chair is in doubt. Ayes, please stand. '41. Apparently I need to get my hearing checked. We are back on the bill. Question being called. All those in favor of Representative Walters' motion that the committee of the whole rise to report, it do so with the recommendation that House Bill 132 do pass. All those in favor, say aye. All those opposed, say no. That definitely does not pass. Pursuant to House Rule 6-6B, having the bill failed a voice vote, a standing division vote is required. All those in favor, please stand. All those opposed, please stand. Having failed the standing division vote, a roll call vote is required. Chief Clerk, please call the roll.
Andrew. Tap the gavel. Andrew. Baker. Banks. Bear. Blackburn. Brown, excused. Oh, Brown. Burkhart. Burt. Clausen. Clifford. Connolly. Crago. Duncan. Eklund. Air. Flitner. Fortner. Gray. Greer. Hallinan. Haroldson. Harshman. Heiner. Henderson. Hunt. Jennings. Kenner. Knapp. Larson Lloyd. Larson Dan. McGuire. Martinez. Nyman. Newsom. Nicholas. Oakley. Obermuller. O'Hearn. Olson. Ottman. Ottman. Paxton. Provenza. Roscoe. Schwartz. Sherwood. Simpson. Summers. Stith. Stivar. Sweeney. Walters. Washit. Western. Wharf. Williams. Wilson. Winter. Yin. Zawanitzer. Mr. Speaker. Closing vote. Are there any changes? Closing vote. The vote is closed. 14 aye, 46 no.
Having failed a roll call vote, House Bill 132 is indefinitely postponed. The next bill for our consideration is House Bill 207. The reading clerk will please read the bill.
House Bill 207, sponsored by Representative Haroldson. Coal-fired generation facility closures, litigation funding, an act relating to the administration of government. Mr. Speaker, Your committee number 9, Minerals, Business and Economic Development, to whom was referred House Bill 207, Coal-Fired Generation Facility Closures Litigation Funding, respectfully reports same back to the House with a recommendation that it do pass with the following amendments. Ayes, Representatives Bear, Burkhart, Duncan, Air, Gray, Greer, Heiner, Sherwood, Western. Representative Greer, Chairman. This bill was re-referred to Committee number 2 Appropriations. Mr. Speaker, your Committee number 2 Appropriations, to whom was referred House Bill 207, Coal-Fired Generation Facility Closures Litigation Funding, respectful report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Kenner, Larson Lloyd, Nicholas, Simpson, Stiff, Walters. Noes, Representative Schwartz. Representative Nicholas, Chairman.
Chairman Greer.
Thank you, Mr. Chairman. I move that when the committee of the whole arises reported, do so. The recommendation that House Bill 207 do pass. Mr. Chairman, I'll first move Standing Committee Amendment number 1, coming out of the Minerals Committee. I'll do a quick explanation of that and try to dispense with it. So members, Standing Committee Amendment number 1 basically does three things. It sets up an account for this litigation fund that's going to be discussed within the bill, and that's the primary purpose of it. Second is it changes the reporting date to the Minerals Committee of the status from November to October, and that's just to help with our meeting schedule. And then the third thing that it does is line 2, page 22, is it was just some cleanup language that the committee thought was necessary. Now, Mr. Chairman, with respect to page 2, line 22, I need a technical correction. On line 22, the Standing Committee amendment should say other states in the United States have enacted and enforced laws. The "in the" was left off of the amendment. It has been deleted out, and that is a technical correction. I'd ask for ruling on that.
The chair rules that it is technical. Please continue.
Okay, so basically, members, I mean, I can walk through line by line, but what we did is we set up an account to put the litigation funds in. We could get 2 old appropriators on the Minerals Committee. We just made sure there was an account and nobody else could get after this money. And then we changed the date concerning when the report should come to the committee. So I'd take any questions on that Standing Committee amendment.
Question being called on Standing Committee Amendment number 1 to House Bill 207. All those in favor, say aye. All those opposed, say no. The amendment is adopted. So you're back on the bill.
Okay,
Chairman
so then,
Greer.
Mr. Chairman, there is a Standing Committee amendment coming out of Committee number 2. And I'll go ahead and move that Standing Committee amendment. They did, and we discussed what was the appropriate amount to go into the account. And they gave it a little bit more than a haircut, but I know the sponsor was working with them. And they reduced that down to $500,000. And so there's no questions on that. I go ahead and move that Standing Committee amendment and move forward.
Any discussion on the amendment? Oh, Representative Schwartz.
Thank you, Mr. Chairman. So just for the record, in the committee that made that amendment, I made a suggestion of amendment to reduce it to $100,000, which I stated I thought was being very generous. So I will be in opposition. I will actually support this amendment because it's better than the original, but it's still not enough.
Any other discussion? Question being called. House Standing Committee Amendment number 2 to House Bill 207. All those in favor, say aye. All those opposed, say no. That amendment is adopted. We are back on the bill. Chairman Greer.
Mr. Chairman, it's my pleasure to turn the explanation of the bill over to the distinguished gentleman from District 4.
Representative Haroldson.
Thank you, Mr. Chairman, and thank you, Chairman of Minerals. Before you guys today, we have House Bill 207, and we're going to end on a good note today. Okay, guys? So we're going to talk about February 10th through the 20th. Why do those dates matter, and why do those matter to the state of Wyoming? The 10th through the 20th were the days when the state of Texas and Oklahoma saw a crazy winter storm that decided to wreak havoc on the reliability of their power generating units and systems. And through that, we got to see a power outage that ran through that state and ended up costing that state around, they're estimating $195 billion. And that's, I mean, that's mind-boggling, absolutely mind-boggling that this would be something that would happen. The blackouts, they're estimating cost over 70 lives. And when the governor was asked the reason for the blackouts, he stated that it was frozen wind turbines, solar panels, and frozen natural gas equipment. And why do I bring this up? Because we are currently in the state of Wyoming sitting in a position where we have had other states come against our generating units or generating cooperatives and told them you have to abide by a certain energy portfolio. And so real quick, I'll just explain that an energy portfolio says you have 100%, and out of your 100%, a certain percentage has to be renewables or has to be generated in a renewable way. And I'll say right out of the gate, I'm not opposed to seeking a renewable energy portfolio, but it cannot sacrifice reliability, because reliability saves lives. Reliability creates the culture and the type of life that we love to have here in America. And so reliability was lost in Oklahoma and in Texas from the 10th through the 20th of February. And I will tell you right now, in 2019, Colorado passed legislation in House Bill 1261 and then Senate Bill 236 that placed a 80% renewable portfolio requirement upon an entity, a power generating entity that services a large part of the state of Wyoming, as well as Colorado and New Mexico. And this facility or this generating service owns 23% of the power plant located in my community. And if this 80% renewable portfolio goes through, there is a potential or a possibility that in 2033, we will lose portions of our power generating facility in the county that I represent. And so this is a severe issue. And as a meeting went together and I was able to sit in on a meeting of these power cooperatives, they were making the comment that it's unbelievable, as well as, in some people's opinions, unconstitutional for the state to the south of us to do this to Wyoming. And so the conversation went that in 2014-15, the state of North Dakota sued the state of Minnesota over a breach of commerce clause, and in 2 consecutive court hearings were able to win that lawsuit. And so out of that came this concept of House Bill 207. So if we look at this, it is an opportunity. We first establish the need that we are in the state of Wyoming under Section 1. We find that Wyoming is the largest producer of coal in the United States. We talk about how coal is used in our power generation, and it brings the reliability to our system. And it also goes through and talks about how there has been demands placed upon the state of Wyoming to lower its generation of power through coal and bring it into renewables. And again, like I said, please hear me right. I'm not against renewables. I'm against a lack of reliability. Reliability means you can walk to the wall and turn on the switch. Reliability means your furnace still runs in the middle of a crazy cold spell. When God decides the sun isn't shining and the wind isn't blowing, and it's cold enough that the gas units are not able to get fired, then we've got a serious problem. And I don't want to see Wyoming being brought to the place that we got to see Texas and Oklahoma go. So this is funding to give the executive branch. Sorry, I'm a preacher. This is funding to give the executive branch the ability to take and to give us an option as the state of Wyoming to say, you know what, no matter what the state is, you're not allowed to do this to us. And I'll be completely honest with you, for a long time, I feel like we've seen legislatures in other states wag the dog in a way. And I don't think that's appropriate. I don't think that's right. I think the state of Wyoming needs to stand up, and we've heard it time and time again. You know, our education comes through our coal. It really does, you guys. It comes through the ability for us to be a strong, independent, opportunist type state that says, you know what, not only will we produce, we'll export. We'll take care of the states around us and make sure that they have power that is reliable so that they don't have to worry about what happened in another state like in Texas and Oklahoma. And so House Bill 207 gives the funding to the executive branch to enter into legal ramification against any state that would come against our ability to generate power or export coal here in this state. Where is the funding coming from? There was extra money in the coal litigation funds, and that's where the funding came from. Originally, it was 1.2 million. We've backed that down to 500,000, and that's okay because we have a great, we've got a great staff of lawyers that can pursue this in this state. This would just help shore up any loose ends that would come from this litigation. So the executive branch has been contacted with this. They said, we love the concept. We love the idea. We'd love to partner with you as the legislature. And I would ask today that you guys would consider this and favorably consider this as we move forward in the opportunity to bring us that home run of saying, you know what, we're going to stand up as the state of Wyoming and we're not going to allow you to walk on us. And I think it's going to be a statement that we make as a legislature. It's going to be a statement the executive branch in this state's going to make against other states and we actually can say, you know what, when you make those decisions legislatively or executively, there will be recourse because we won't back down. I think it's time that we fight if we're going to keep the economy of our state vibrant. It's going to come with us fighting for it. So with that, I stand for questions.
Representative Yen.
Thank you, Mr. Chairman. So my question is, can you convince me that we're going to win? Because if we start throwing $500,000 at lawyers, I mean, I love the lawyers in this room, but I don't particularly want to just give away $500,000 of our general fund to lawyers unless I think we can get a good return on our money, right? So do I think, for example, if I thought California could sue us and tell us we had to do renewable energy, do I think they could beat us in that kind of lawsuit? No, I don't think they could. So, you know, honestly, I don't know if we could win in a lawsuit in this distinction. So before we throw $500,000 to a lawyer, I want to be convinced that we can win this lawsuit. Otherwise, I mean, we just cut a bunch of services from a bunch of different places that could really use $500,000. And I'm not sure if this is the best use of $500,000. So please convince me that we can win this lawsuit. Thank you, Mr. Chairman.
Representative Stiff.
Mr. Chairman, to address the concern from the good representative from District 16, I don't think anyone is going to promise a certain victory, but the issue here is a rather interesting issue, legal issue of the Dormant Commerce Clause. So for example, if California, if Wyoming were to adopt a statute that said that no wine may be imported into the state of Wyoming unless that wine is made from grapes that are grown at an elevation of 6,000 feet or more, that would likely violate the Dormant Commerce Clause because we would be excluding California from being able, and vintners in California who are growing their wines at elevations lower than 6,000 feet, we would be artificially excluding all of those products from our market. And so the Commerce Clause, which was one of the biggest reasons why we became the United States of America, essentially has this provision that says you can't discriminate against products from other states. So the issue is, if another state says, we will not buy any electricity unless it's generated from certain kinds of renewable sources, then theoretically that excludes a product that's made with fossil fuels from our state. And so I think that's the basis of the good faith basis of the Dormant Commerce Clause claim. Will that win? I don't know, but we have a lot at stake. And so if we have, let's imagine we've got $100 million at stake, right? And we've got a 10% chance of winning a lawsuit, right? 10% is not very good, but if you can win $100 million and you have a 10% chance to, then it's rational to spend up to $9.9 million to do that. So this is just $500,000 for lawyers, which is always a good thing. Thank you.
Representative Harrelson.
Thank you, Mr. Chairman. And to answer that question, obviously, I will agree that we don't know for sure, but the fact that the lawsuit from North Dakota versus Minnesota came after Minnesota put a legislatively based renewable portfolio upon the state of South Dakota and the state of North Dakota and said, you will only produce 70% renewables. Well, the lignite coal belt said, that's impossible. And North Dakota said, you know what, it's worth a shot. So they went, and it did not make it to Supreme Court, it was district court, but it got into district court. And the district court, the federal district court ruled in favor of the state of North Dakota. The state of Minnesota repealed. They ruled for a second time in the favor of state of North Dakota, and they had to drop that legislation that put a renewable portfolio upon the state. So in essence, it's the exact thing we're dealing with right now in regards to this power cooperative that has ownership in the power generating unit that we have in House District 4 and the state of Colorado. And so if we as the state of Wyoming were to stand up for that cooperative and say, you know what, and it isn't just that cooperative, it's the state. Because, and my issue is renewable the answer someday? It may be, but right now we don't have the technology required to make this reliable. So this isn't, I don't think this is a battle of coal or no coal. This is a battle of reliability. And we don't want to look like a third world country, or we don't want to look like a rolling brownout type state, or the state that says, you know what, oh no, we just had 40 inches of snow in our county. But you want to know something that was really interesting? Power kept coming out of that unit. They kept producing. Why? Because it's reliable. You want to know what else is awesome? We're paying 7 cents a kilowatt. Come on, somebody. That's something we need to think about. Go and call friends that you have down south and ask them what they're paying on their renewable portfolio plans. You're not going to get 7 cents. So I think it's something we definitely need to think about.
Representative Hunt.
Thank you, Mr. Chairman. On in support of the bill. The good member of appropriations from Sweetwater County was discussing, odds and probabilities and such. And I guess I would say, how does this hold up in court? I don't know, honestly, but I think that what is certain is that if we don't set this money aside, and if we don't try, then there's 100% chance that we fail. And I guess my point being is that you don't know until you give it a shot. And maybe it never comes to that, but I think that it's good to hedge our bets and put this aside just in case, because having seen what happened in the South last month, and in having discussions with folks in helping put this bill together, I mean, if you can imagine down the road a few years from now, that there's another similar cold snap, right? And it's 20, 30 below from here all the way down the Front Range to New Mexico. And because of what Colorado has done and its energy policy, it suddenly has a crisis like what Texas faced a few weeks ago. And I mean, are we going to be beholden to bail them out of the black hole that they've created for themselves? I don't know. But I think that if we have this ready to go, just in case, we reduce our risk overall, because I don't want to see Wyoming left holding the bag to try and accommodate for what potentially Colorado has done to itself in the future if it makes its own energy grid so unreliable as to have a meltdown similar to what happened in Texas. So on in support of the bill. Thank you.
Question being called. Oh, sorry, Representative Provenza.
Thank you, Mr. Chairman. And to the bringer of the bill, I have a quick question. And it sounds like there's some concerning information about reliability of renewables. And I'm wondering if you have any information in terms of any of our wind turbines or any of our renewable energy here failing during maybe this massive snowstorm or during our crippling, very cold days throughout almost most of the year. Thank you.
Representative Harrelson.
Thank you, Mr. Chairman. So to answer the question, you need sun to hit solar panels to get power out of a solar panel. And so snow will impede solar panels capabilities. So I will say this, under a snowstorm, solar panels receive zero output. The other issue is this, there's no way to de-ice a wind blade. They've not come up with a way to do it yet. So I'll give you an example of what happened. And obviously I could make phone calls and I'd get you for sures if you want me to, but I will just tell you what happened in the last crazy storm. There was a 900 megawatt field. The 900 megawatt field produced 2 megawatts. This is a solar and wind field, 2 megawatts out of 900. That's unbelievable. And then on top of it, it took 37 megawatts back off the grid to be able to power the brakes and heaters for the turbines. So it had a net loss of 35 megawatts. Okay, so the other issue they say, we need battery banks. We need battery banks. Right now, the technology is 4 hours on a battery bank. That situation lasted 10th through the 20th. That's not 4 hours, not even close. So the technology isn't there for that. Every single megawatt of renewables needs to be followed by a megawatt of fast fire generation, meaning that you have to have a gas turbine. It's basically like a 747 jet engine. That has to be sitting there ready to fire up as soon as you don't have that base load off of renewables. So when that happens, we've lost power through renewables. We have to fire up a gas generator. In this situation, they were not ready to do that because they did not have them capable of firing up in the cold temps. So right now, what's our wind fields putting out during this storm? I will promise you, at least in our area, we had a crazy amount of wind and then a lot of dead still and snow covering everything. So our renewables were not producing. I can pretty much guarantee 99%, at least in the area that I live, the renewables in that area were not producing at that moment. And so what they did is well, and I'm not going to go into all of how we do our transmission system because we don't have time. It doesn't matter. But so yeah, the renewables in a storm like this are not the answer because they just cannot run and they cannot operate.
Representative Ottman.
Yes, thank you, Mr. Chairman. To the speaker on the bill, I just wanted to reiterate, is this bill, does it follow along the lines that because like gas and oil, the new commission that has been made for that, and with coal and the dependence and reliability over the years that we've had with coal, does this bill put the premise that in case the states around us threaten us with blockage, that we would be basically break our backs, that we would have to give these plants up? Is that what this support is for, that we can just maintain and keep our own sovereignty as a state? Thank you.
Representative Harrelson.
Thank you, Mr. Chairman. Yes, this would give we would keep sovereignty. Now we can't make anyone buy anything because they have sovereignty. So we can't be like, you have to buy our power. Well, they can choose not to. But the problem is there's not enough generation to curtail load or to actually take care of the demand. And so as of right now, they couldn't do that. They couldn't be like, never mind, we won't buy the power because they need the power currently. They just want these cooperatives to figure out a way to make it renewable. And honestly, at the end of the day, there is no such thing as renewable because it takes a ton to actually build the panels and the blades and all of that. So, and to dispose of them. So you can ask anyone from the center of the state what happened to their landfill when they decided to throw the wind turbine blades away. I mean, there's some issues all the way around. And so this is just, again, let's take care of reliability. Let's take care of our economy. And with that, I call the question.
Anyone else? Question being called on House Bill 207. All those in favor, say aye. All those opposed, say no. The ayes have it. House Bill 207 has passed committee of the whole. Majority Floor Leader Summers.
Mr. Chairman, I move that the Committee of the Whole rise and report.
You've heard the motion. All those in favor, say aye. All those opposed, say no. The ayes have it.
Reading clerk will read the committee of the whole report.
Mr. Speaker, your Committee of the Whole, having had under consideration bills on general file, beg leaves to report as follows. House Bill 236, do pass amended. House Bill 165, do pass. House Bill 164, do pass amended. House Bill 166, do pass amended. House Bill 228 failed to pass Committee of the Whole and was indefinitely postponed. House Bill 171, do pass. House Bill 198, do pass amended. House Bill 217, do pass. House Bill 190, do pass. House Bill 125, do pass. House Bill 132 failed to pass Committee of the Whole and was indefinitely postponed. House Bill 207, do pass amended. Representative Western, Chairman.
Go ahead. Representative Western,
I move for the adoption of the Committee of the Whole report.
you've heard the motion. All those in favor, please say aye. Those opposed, no. Congratulations, Chairman Western. Thank you very much, members. Messages from the Senate.
Message 242. Mr. Speaker, the bill listed below passed the Senate on third reading in amended form by the vote indicated. Senate File 113, Business Ready Communities Amendments, ayes 21, noes 9. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 243. Mr. Speaker, the bill listed below passed the Senate on third reading by the vote indicated. Senate File 146, 6-person juries in civil cases, ayes 29, noes 1. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 244. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 147, Management Council Authority and Legislative Committees, ayes 30. Sincerely, Ellen Thompson, Senate Chief Clerk. Message 245. Mr. Speaker, the bill listed below passed the Senate on third reading in an amended form by the vote indicated. Senate File 143, School Finance Funding Model Amendments, ayes 24, noes 6. Sincerely, Ellen Thompson, Senate Chief Clerk.
Reports from standing committees.
Mr. Speaker, Committee Number 3 Revenue, to whom was referred House Bill 146, Personal Property Depreciation, respectfully report same back to the House with the recommendation that it do pass. Ayes, Representatives Baker, Gray, Hallinan, Harshman, Jennings, Sweeney. Noes, Representatives Henderson, Roscoe, Nguyen. Representative Harshman, Chairman. Senate File 25. Correction. Mr. Speaker, your Committee Number 5, Agriculture, State and Public Lands and Water Resources, to whom was referred Senate File 25, Engrossed, Animal Impound Proceedings, Bond and Disposition. Respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes, Representatives Blackburn, Clausen, Eklund, Fortner, Heiner, Larson, Dan, Western, Winter. Noes, Representative Wharf. Representative Eklund, Chairman. Mr. Speaker, your committee number 6, Travel, Recreation, Wildlife, and Cultural Resources, to whom was referred Senate File 88 engrossed, ownership of fossils and artifacts, respectfully report same back to the House with the recommendation that it do pass. Ayes. Representatives Banks, Flitner, Haroldson, Hunt, Jennings, Knapp, Newsom, Sweeney, Winter. Representative Flitner, Chairman. Mr. Speaker, your committee number 8, Transportation, Highways, and Military Affairs, to whom was referred Senate File 106, Transportation Statutory Amendments 1. Respectfully report same back to the House with the recommendation that it do pass. Ayes. Representatives Baker, Brown, Burkhart, Burt, Henderson, McGuire, Obermueller, O'Hearn, Stivar. Representative Burkhart, Chairman. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom was referred House Bill 161, Human Life, Equity, Equality, Prohibiting Discriminatory Abortions. Respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes. Representatives Flitner, Hallinan, Ottman, Romero Martinez, Stivar, Wharf, Wilson. Noes. Representatives Clifford and Connolly. Representative Wilson, Chairman. Mr. Speaker, your committee number 10, Labor, Health, and Social Services, to whom was referred House Bill 253, University of Wyoming, Ban on Funding for Abortions. Respectfully report same back to the House with the recommendation that it do pass with the following amendments. Ayes. Representatives Flitner, Hallinan, Ottman, Romero Martinez, Stivar, Wharf, Wilson. Noes. Representatives Clifford and Connolly. Representative Wilson, Chairman.
Mr. Majority Floor Leader.
Mr. Speaker, I move that the House adjourn until 10 a.m. tomorrow, the 19th day of March, 2021.
Committee announcements. Chairman Zwanitzer.
Thank you, Mr. Speaker. Committee number 7, Corporations, Elections, and Political Subdivisions will meet tomorrow upon noon recess to hear the following 3 bills. House Bill 16, Improvement Service Districts, House Bill 256, Wyoming Sovereignty, and House Bill 72, Transfer of Water Operations.
Chairman Paxton.
Thank you, Mr. Speaker. Your committee number 4, Education, will meet in room E3 tomorrow upon noon recess to consider House Bill 77, School District Reorganization, House Bill 175, Suicide Prevention 2, House Bill 147, Education Expense Tax Credit.
Chairman Wilson.
Thank you, Mr. Speaker. Your committee number 10, Labor, Health, and Social Services will meet tomorrow morning at 8 o'clock in Extension Room 3 to consider 2 bills, Senate File 30, Pandemic Response Review Task Force, and Senate File 52, Insurance, Mental Health, and Substance Use Parity.
Chairman Olson.
Mr. Speaker, Judiciary will meet tomorrow at 8 a.m. to consider House Bill 210, Minor Sex Traffic Victims Liability, Senate File 101, Pen Registers and Trap and Trace Devices Authorization, and Senate File 124, Defending Wyoming Business, Trade, and Commerce Amendments.
Chairman Harshman.
Thank you, Mr. Speaker. Your Revenue Committee number 3 will continue its meeting upon adjournment after the caucus in West Room 3 to continue the following bills: House Bill 211, Property Taxes, House Bill 162, Medical Treatment Opportunity Act. Thank you.
Chairman Nicholas.
Thank you, Mr. Speaker. Your House Appropriations on adjournment will hear Senate File 993 and 120 and the continuation of House Bill 244, substitute bill. Tomorrow at 8 a.m., your House Appropriations will hear 263, House Bill 263, and Senate File 35, 58, 72, and 119. And if whatever we don't get done by 9:30, we'll carry over to the noon hour. At the, we'll be in 301, room 301 at 8 o'clock, and on the noon hour, 311.
Representative McGuire.
Thank you, Mr. Speaker. Privilege of the floor.
Please proceed.
The House Republican Caucus will meet in 15 minutes in the Extension Auditorium. Thank you.
Any other announcements? Any other announcements? Mr. Majority Floor Leader.
Mr. Speaker, thank you. So, ladies and gentlemen, we have 2 more days at Committee of the Whole. And I'm going to save probably the hardest and toughest bills for the last day, so we only really get mad at each other hard once. And so for tomorrow, the Committee of the Whole will be, well, I'm hoping the Committee of the Whole will be 205, House Bill 249, House Joint Resolution 9, House Joint Resolution 11, House Bill 197, House Bill 142, House Bill 143, House Bill 243, House Bill 170, House Bill 153, House Bill 187, and House Bill 146.
Is that all, Mr. Majority Floor Leader? Thank you, Mr. Majority Floor Leader. So members, just to ensure you're recognized, tomorrow we'll be taking up the 2 bills that were laid back today on second reading, or on third reading. They were laid back. So we'll have, there's at least 13 amendments right now on 173. So I guess we have a full afternoon. Just so the members know, as a little heads up, we will have one of our U.S. senators here tomorrow addressing the body. It's a courtesy that we certainly look forward to having Senator Lummis here with us tomorrow, soon after we convene. So try to be here promptly at our convening time. I don't know if she's going to start in the Senate or the House side, but we will have that. We'll do second reading, and then we'll have our explanation of the budget, probably about a 30-minute, 25 to 30-minute explanation, unless you ask a lot of questions, and then it may be longer. And then we'll be continue with our continue with the third reading business. Further announcements? Further announcements? Seeing none. Members, all those in favor of the Majority Floor Leader's motion to adjourn until the Friday, March 19th, 2021 at 10 a.m., please say aye. Those opposed, no.